Nothing's happening.
They're both withdrawn. Good evening, ladies and gentlemen. This is the March 19, 2009 hearing of the Radnor Township Zoning Hearing Board. Before we begin, we have a number of administrative items. Appeal number 2802, AT&T Mobility, and appeal number 2803, also AT&T Mobility, have been withdrawn. We've received correspondence from counsel for AT&T Mobility, Mr. Hipp, withdrawing those applications, so they will not be heard.
Are they continued or withdrawn?
Withdrawn altogether. Yep. The next matter we have is with respect to appeal number 2808. Gary E. and Christina M. McLean, owners of property located at 121 Runnymede Avenue, Wayne, zoned R5 residential and in Ward 6. I won't go through the details of that application at this point because we've received a letter dated yesterday from counsel for the applicant, Mr. Flail. It's a letter to me, and it reads, applicants hereby request a continuance of the hearing scheduled for March 19, 2009 to the April 16, 2009 meeting. The reason for this request is that John E. Ryan, Esquire, has raised the issue that the board lacks jurisdiction to hear this appeal because of the outstanding appeals to the Court of Common Pleas of Delaware County of the board's decision on appeal number 2545 on this property. In the interim, the applicants will attempt to determine whether there is a counter argument to Mr. Ryan's opinion, or if not, whether there is something else which can be done to allow this appeal to proceed. John, would you share with us your view of the situation?
Yes, this was a decision which the zoning board granted a variance by estoppel based on really unique facts in January of 2003. Both the applicant and the neighbors appealed that decision to the Court of Common Pleas. And when the applicant's brief in the new appeal seeks a relaxation of conditions that were attached to the 2003 decision, when their memo of law came in, which, by the way, I've put in all of your, I've given you all a copy, it was disclosed that at least the applicant's appeal is still going. And then in subsequent discussions, I found out that the neighbor's appeal, both of these appeals are live appeals in the Court of Common Pleas, which are not resolved. And there is a case, Abe Oil Company v. Zoning Hearing Board of Richmond Township, a 1994 Commonwealth Court case, which says that if an appeal of a zoning board decision is filed, the zoning board is immediately divested of any jurisdiction over the matter. And it is my view that while these appeals exist, this board, on the basis of Abe Oil, has no jurisdiction to entertain this appeal on the merits. And I believe in the letter they want to try to see if there's any contrary authority. They're welcome to do so, although I did have the Abe Oil case checked, and it's not the first time I've checked it in the last few years. We've had other instances before this board where Abe Oil has come up. And so my advice to the board is, unless I can be pointed to authority which is contrary to Abe Oil, this board has no jurisdiction to consider this matter on the merits until both appeals are withdrawn from court. While any appeal exists, I don't think we can hear it. If the board were to grant the continuance, which certainly makes sense to me, I would suggest that if there are going to be any memoranda of law filed, that we get them in maybe a week before the next hearing so that I can review them with the board and offer my thoughts.
I have no trouble with the extension, and I would like to have the applicant bring in the brief so that John has time to digest it and so that he can give us his advice. Do you guys have any comments or concerns on that? You okay with that, Cora? Okay, so we'll grant the extension, and we'll let Mr. Flail know that his brief on the issue, should he care to file one, is due April 9.
Okay.
Okay. The next matter we'll hear is appeal number 2798, Robert and Leanne McMenamin, owners of property located at 416 St. David's Road, Wayne, zoned R2 residential and in Ward 3. Applicant seeks to expand an existing non-conforming rear deck which will not increase the existing nonconformity with regard to the side yard setback. Current side yards for both the existing wood deck and house is 17.1 feet and 17.8 feet from the respective property lines. Applicant's deck expansion will be no closer than 17.1 feet and 17.8 feet from the respective property lines. Current side yard setback for the existing stairs to the deck is 11.1 feet, while the replacement stairs will be 12.3 feet from the property line. Applicant seeks a special exception pursuant to 280-101B of the zoning code and/or a variance or a de minimis variance from section 280-20D of the zoning code, or contends that the relief is permitted as of right. Applicant also seeks a variance and/or a de minimis variance from section 280-20F, or contends that the relief is permitted as of right to consolidate two existing driveways into one and reconfigure the driveways on the property. The property with the current improvements has an impervious coverage of 30.9%, which is an existing nonconformity as to impervious coverage. The proposed driveway configuration, along with the proposed deck expansion, would increase the impervious coverage by 308 square feet, or 1.82%, 0.87%, for a total of 32.72% impervious coverage. Mr. Rhodes.
Yes, thank you, Board. We previously were here, as you may recall, back in November. I represent Rob McMenamin and Leanne McMenamin in this appeal. I have Mr. McMenamin here now. We previously have been sworn in, so I think that should do for us right now, unless it pleases the Board.
That's fine.
Okay. Like I said, as you may recall, we were here a few months ago. We were requesting a variance from 280-20F regarding impervious coverage, relief on impervious coverage for additional 1.8%. We're also seeking a special exception over 280-101B to expand a deck into an area which is already encroaching by the existing building. At that last meeting that we were before you, you requested us to relook at the plans, see if we could shave down some of the impervious coverage to at least meet the existing grandfathered condition of 30.9, and we have done that.
Great.
I
believe that conforms with my recollection. I think really what we were left with was the impervious.
Exactly.
As to any concerns that were expressed.
Exactly. I have plans here that will actually revise Exhibits A5, will actually replace and revise Exhibits A5, A6, A7, and A8. The plan I'll be handing up to you is dated March 18th, 2009, hot off the presses, and I'd like to also introduce to the Board I'd like to exhibit as A12, and then I'd like to introduce to the Board an enlargement of the rear deck area, which I'll introduce as Exhibit A13.
Thank you. Mr. Rhodes, before we begin, why don't we walk through and we'll go through and pull out the prior exhibits and replace them with the new ones.
Exactly. Well, I guess
These maybe should just be added as new exhibits, in other words.
Okay, and then we'll have the whatever, if there's a decision with reference to the new ones.
Yeah, that's exactly what
Okay.
we would do.
I've pre-marked the full plan as Exhibit A12.
Okay.
Which would be the full plan, last revision date 3/18/09, and then the smaller enlargement as Exhibit A13.
Okay.
They will revise, like I said, and replace the prior exhibits A5, A6, A7, and A8.
Okay, so I'm not seeing where the marking is on the big plan.
I might have missed a few. I labeled it on here, but you have to
Okay.
jot that down.
But this
Okay.
is A12.
Yeah,
That
the
would be
large one is
A12.
A12. Small plan is A13, and these are the governing plans.
So by revising the plans and taking care of the impervious coverage, we've gotten it down so it is now in line with what is previously on the site as non-conforming, 30.9, so we're withdrawing the request for variance for the impervious coverage for this board, because I think,
And so it becomes a special exception application?
I don't believe so. I think by amount of right, it's a grandfathered nonconformity. It's not dealing with building, it's not an enlargement, and I believe this board in the past has interpreted driveways and roadways as not buildings.
Okay.
So therefore, I don't think it falls within the 101B exception.
John, what are your thoughts on that?
Well,
In the alternative, I would seek a special exception under.
Of course. But if we don't have to address it, we don't have to address it.
is your building totally over existing stuff? I'm looking at the new plan. Are you building anywhere where you don't have something right now?
I think we're just talking about the driveway now, John, and the impervious.
Okay.
But the deck would be built over a small portion that isn't previously there.
Right, but it
the
doesn't
extent
increase
extend
the,
any further back.
No,
right, it doesn't increase the existing
Exactly.
nonconformity.
So
Right.
that is a 101B1
But
special.
as to the deck, yes,
Yeah.
but what about the impervious question?
There's no relief needed. If he's gotten it down to existing nonconformity,
Okay.
there's no relief needed.
Okay,
Okay, that's what
so the application then is just limited to
A 101B exception.
101B1 for the deck?
Exactly.
Okay.
Do you have the calculations, how you?
Yes, on the top of the full plan, you'll see the proposed calculations. The existing square footage on the site is 5,214 at 30.9%, which is the grandfathered nonconformity. And the proposed impervious coverage is exactly the same, 5,214 at 30.9. Actually, with the revisions, we do bring into conformity the building coverage from over 18.69%, and we actually bring that into conformity at 17.86% below the 18% mark. So we're just before you for the rear deck.
For the deck, okay.
May I just ask, it appears that you narrowed the driveway as it hits the garage. Basically, it was 12 before, and now it's 9. Is it 9 feet the length of the driveway?
I believe so, yes, the length of
Okay.
the driveway. They also narrowed
The
the
porch.
horseshoe to 9
They did?
it used to be 10 feet. It's now down to 9 3/4. They also narrowed the deck and took pieces off
Right.
the deck.
Okay, thank you.
Do any other members of the board have any questions or comments? Do any members of the audience have any questions or comments regarding this application? Okay.
I'd request movement into my exhibits into evidence.
Okay. Peter, you want to do this one? You all right with it? Or you want me to do it? I'm happy to do it.
I recommend we approve the application as made.
Okay. I agree. Kathy?
I agree. That would be 28101B1 because it's not expanding beyond what the current nonconformity is.
Okay.
And there's no longer a need for a special exception or variance on impervious since it meets the pre-existing condition.
Okay. Cora? Okay.
Thank you very
Great,
much.
Thank you.
Thank you.
The next matter is appeal number 2809, Charles B. and Martha G. Berniker, owners of property located at 107 Hillside Circle, Villanova, PA, zoned R3 residential and in Ward 3. Applicant seeks to construct an addition to the rear of their home. Applicant's residence is currently non-conforming in regards to rear yard setback, in that they constructed a deck 20 feet from the rear property line pursuant to a variance received in 1999. The proposed new addition will be 4 feet further from the property line than the existing nonconformity. Applicant seeks a variance from Section 280.25E of the Code or a special exception pursuant to Section 280.101B or such relief as required by the Board. Mr. Cornelia?
Evening, Nicholas Cornelia, representing the applicant. Charles Berniker. Charles, we have, first, you're the owner of the subject premise, is that correct?
Yes, my wife and
And And we've marked as A2 the deed to the property. A2 is the deed to the property.
Correct.
And you purchased it in 1997.
Correct.
And who do you live there with? Your wife and?
And 4 children.
And when was the house built?
Roughly 1940, early 1940s.
Okay. And you had come before this board to get relief previously, is that correct?
Yes, we have.
And I've marked that as A3, correct?
Yes.
All right. And just to show the board, we've marked as A4. And if perhaps you can tell the board where that prior relief was located and what you're asking for here this evening.
Okay. The prior relief was the back of the house. It's shaded gray with a white extension on it there. And that section is an existing deck, which we're going to be removing.
So you're talking, go ahead if you want to use that. You're talking about this area here, all the way up to the white portion is where the prior variance was granted?
Correct.
Okay, and what you're intending to do, you're actually removing that white area there, is that correct?
Correct.
And then you're just extending it across the rear?
Correct.
All right, and actually the prior variance was 20 feet from the rear property line?
Yes, it was.
And this request is you're moving it further back. It will be 24 feet from the property line?
Correct.
And actually, it even goes further back to 33 feet.
Correct.
Is that right? What is located behind you?
Behind us is a wooded area with a distressed home on one corner, as well as a commercial property, which is a physical therapy office.
Okay, and
Which
what
is
do you,
Lancaster Pike.
right, you back up to Lancaster Avenue, is that correct?
Correct.
Okay,
And the train.
right. And your property here is actually a pie-shaped, almost a classic pie-shaped lot?
Correct.
And the existing home, how many square feet is it? Would it be accurate to say 1490?
That would be
The footprint?
correct.
All right, and so actually you have about 2,800, I guess, on both floors, is that right?
That is correct.
Could I just interrupt, just so I understand? The deck that exists now, and which was approved by variance, includes all of the cross-hatched areas plus the little white area to be pulled back.
Correct.
The addition will be over the cross-hatched areas. The 2 cross-hatched areas will be converted to the addition.
Correct. And the white spots that appear on this drawing will not be there.
Yeah, so you're going to pull, basically you're going to get rid of the deck and
Correct.
replace it with the addition.
Correct. And this shows as though they're adding a deck here. We're not doing that. We're going to leave it at 20. We're going to go to 24.
Okay,
Yeah.
so this deck to be removed.
Yeah, it says portion of deck to remain, actually, is supposed to be portion of deck to be
That
removed.
should be said to be removed.
Okay, we should correct the plan on that.
And what's the purpose of the addition?
Purpose of addition is to expand the. Oh, sure. The purpose of the addition is to expand the first floor living area, specifically the kitchen and the dining room.
And is it a one-story or two-story addition?
It's primarily a one-story addition. Where the current deck is actually a 2-story addition, which is an 8-foot by 15-foot 2-story, and then the major piece in the middle here is a 1-story.
Okay, and what's the size of the current kitchen?
Current kitchen is roughly 10 by 10.
To show you what we've marked is A5, and these are some photographs, and you can just tell the board and go through those photographs and tell the board what they represent, please.
Sure. The photo 1 represents the lot that's closer to Lancaster Avenue, which today is a vacant lot. Photo 2 is our house, which is the 107 Hillside, which also shows the neighbor to the other side, the Thompson residence. And then photo 3 is a front view of the home. Photo 4 is the rear.
And this is where the addition would be located and the deck to be removed?
Correct. So on the right side of the deck, we removed and replaced with an addition, which will come out the identical distance as the structure to the left side of the house, which is 8 feet from the brick, and then we're going to connect the two with a 1-story. Photo 5 is a picture of the rear. If you look through, you see if you look in there, that's the P&W train, and continue through, you'll look through and you see the Kinko's building and the commercial property on Route 30. And then the other side is just a little more view of the rear yard as well.
Okay, and you have spoken to the immediate neighbor?
Yes, we have. That would be the Giovannis.
and I'm going to mark as A7. You have a letter from them,
We do.
and if you could read the letter to the board.
Sure. It's dated March 19 to the Radnor Zoning Board, Radnor, PA, RE Appeal 2809, Martha G., Charles B. Berniker, to whom it concerns. We are writing in support of the above referenced appeal on behalf of our next-door neighbors, the Bernikers. We have been neighbors for the entire 12 years they have been in their house and have enjoyed watching them improve their property. The Bernikers shared their plans with us prior to submission to the Zoning Board, and we are pleased to support this appeal. Sincerely, George Javanis and Jane Javanis.
I'm going to show you also what's been marked as A6, and actually you have a bigger plan here showing it. If you could tell the board, this is the rear elevation as to what it will appear on A6, the top rear elevation photo.
Okay. What is your question? What is your comment?
Is that the rear elevation?
Yes,
Is that what
it is.
is
Yes,
that what
it
it's going to appear?
Yes. I believe they have a reduced version of it.
Mm-hmm. Yes. That's all I would have. Just as the exhibits made part of the record, please.
Mr.
I have a
Cornelia?
question, if I might. On A6, the first floor plan, it appears that it's straight across and it goes out onto a deck. So
A6.
that's in opposition to what you've said about removing the deck.
I'm sorry. That deck is going to be removed in this rendering here. That was proposed by the architect, and we just didn't like it, frankly, and we just said we don't want the deck. We just want to go.
Now, it looks like there's French doors coming out. What are they going to go into?
That's going to go out to. We're going to do some kind of a hardscape or a patio, a stairway into this, maybe a stair down into a patio.
And how is the impervious on this?
The calculation is attached. I think it's on here as complete. We're at 23.52, and it's required 35.
Okay.
We're not close. And that's everything.
You probably should correct then A6 also,
Okay.
because that still shows the deck line here.
I think if the board were to approve this, I've already made a note to specifically say in the order that that portion of the deck that is noted to be to remain on A4 is to be removed.
All right.
Okay.
If you want to do that on the township's copy, that'd be fine. And note that. There's no other relief you need other than the rear yard, correct?
Correct.
That's correct.
Okay. And again, this was, I think, this was established by variance, so I think it's, it's outside of 101B1, but they are pulling back from the intrusion that was authorized by variance, albeit for a deck in 1999. So, but it is a variance case.
Are there any comments or questions from the board? Cora, do you have any questions? You're all set. Nick, if you wouldn't mind, could you just talk a little bit about the hardship posed by the irregularly shaped lot, et cetera?
Sure. You have a classic pie-shaped lot, which is irregular, which is a classic hardship here. You also have an existing dwelling that is pushed back to the very rear of the building envelope. In fact, this board deemed fit to grant a variance previously, and we're actually even pulling that back a little bit. The previous variance was 20 feet from the property line. We're proposing it to be 24 feet in one area and 33 feet in the other areas. It goes across the back. But the main portion for the variance is the pie-shaped lot, irregularly shaped lot, and the fact that the structure itself is the very rear of the building envelope.
So although we're not bound by a prior finding that the shape of the lot poses a hardship, we should take notice of the fact that, at least I will take notice of it.
Yeah, I think that's perfectly appropriate to take notice of the prior decision. You're not bound by it, but it's certainly part of the record and, speaks to something.
Right. Does anyone have any comments on that point? Does anyone in the audience have any comments or concerns regarding this application? Sir, please come up. Identify yourself for the record and be sworn.
Hi, I'm Jim Schneller. I live in a spot in the township where I pass the location twice weekly, often daily, and of course.
Yeah, you do.
I swear.
For the record, and this is a monthly occurrence, I have to object to Mr. Schneller's testifying to the fact he doesn't have standing here. This is east, yeah.
Just joking.
Mr. Schneller, how far away from this property do you reside?
Well, there is a
No.
buff,
Yeah. How far away is your?
I would say half a mile.
Do you own any property closer than half a mile to this?
I do not.
Or okay, the board may do as it wishes, but I would concur with Mr. Cornelia that there's no standing in this
Okay.
instance.
Mr. Schnell, if you would keep your comments very brief.
Yes, thank you. And it's totally out of concern for my personal comforts. I could possibly be considered an aggrieved person, and I'm concerned about the township. And the matter is that I don't believe the board has any, should have any ongoing policy of allowing a deck to become a foundation for a later grant of a second variance. I think it's a dangerous policy. I think in this, and no offense to the applicant, I think that we have no indication that property values are helped by a second story. And we have no indication that this is affected at all by the fact that it borders a shopping center. It's a very exclusive neighborhood, and the recommendations of a neighbor should have no bearing whatsoever. So I'd ask the board to please not give a variance and act more in the interests of long-range interests rather than expedience.
Okay. Thank you. Well, I guess from my perspective, a deck qualifies as an extension of the building, correct?
Yes, I believe
And
that.
under the code, if a deck qualifies as an extension of the building, theoretically, it would form the basis for relief under 281-1B1. This, however, is not a 281-1B1 case. It's a variance case, but thank you for expressing your concerns. Kathy, would you mind doing this one?
I would suggest that we grant the variance based on the irregularly shaped lot and where the house is positioned on the lot, which is an older existing house, and that he is pulling giving a little more space to the rear yard setback, so it is minimizing the variance that was given before on this.
Okay, Peter? Cora?
I agree with that decision, but again, we have to take note that we have to come back to the 1999 variance issued to the applicant.
Right, okay. I agree that this is a variance case and that a showing of hardship sufficient to form the basis for the grant of a variance has been made, so it's granted.
Mr. Chairman, it's not necessary for the board to pass on the standing objection, but I think the opinion should note that one was made.
I think that's correct. Okay, very good. Thank you. The next matter is appeal number 2807, Carol McMichael, property located at 215 West Wayne Avenue, zoned R5 residential and in Ward 6. Applicant received approval from the zoning hearing board pursuant to appeal number 2787 to extend an existing nonconformity regarding side yard setback. Applicant appeals a stop work order from the township. Applicant seeks to modify the approval or request a special exception pursuant to Section 280-101B or a variance from Section 280-35A4, or contends that she is permitted by right to raise the home and construct a new residence in accordance with the relief granted by the zoning hearing board. Applicant received permits from the township to demolish the existing building and construct the foundation in accordance with the ruling of the zoning hearing board. Mr. Cornelia.
Evening, Nicholas Keneally representing the applicant. I do have some additional exhibits that I have packeted for the board for this appeal. I've marked them A10 through A18, and we'll hand them. And if you want to swear in the two witnesses.
If you could just raise your right hand. Would you solemnly swear or affirm this testimony that you will do the truth, the whole truth, and nothing but the truth?
I affirm.
I do. Thank you. And state your names, please, one at a time.
Michael Robert Bowerly,
And spell that.
B-A-U-R-L-E-Y.
I'm Carol McMichael.
Four? Oh, that's just a plate. Okay. I was trying to make it easy, but I guess we can't. Just to go through it, and I think if you look at the exhibits, you probably get a feel for what this is about. In September, Ms. McMichael appeared before the zoning board in testimony before the board at that time in response to a question, and a copy of that transcript is in the record. She was asked whether she intended to demolish the building or not, and her comment was she did not know at that time, that the idea was to keep as much of it as possible, but it had deteriorated to such a point that she really didn't know, and they won't know until they really go in and start looking at it. She had also stated there was really no maintenance on the home for about 20 years. The zoning board approved the application, and in fact, nothing has changed as to the footprint. The footprint remains the same as occurred before the zoning hearing board. You may recall that there was a non-conforming garage on the property line that was removed and placed in a different area that made it conforming. Also, the relief granted was because it was not increasing an existing side yard setback. It's not being pushed closer to the road. It's remaining the same distance from the road as it was, which conformed to zoning. The only nonconformity was the side yard setback. And again, it is being maintained at the same location and just extended. The issue that was raised was whether demolition was permitted in accordance with zoning. And there's basically a couple issues in regards to that you'll have to consider. One was that does the applicant in fact require any additional permission from the zoning board? Secondly, if they do require additional permission, are they entitled to it? And the list of cases that I'll hand up, such as Treadle and Amico Oil and Money that I think you've heard before recently, actually a couple months ago. And then thirdly, that Ms. McMichael relied on permits that were issued in October and expended a substantial amount of money on those permits. And those permits, in our opinion, were properly issued by the township. She expended money on both demolition and construction of a portion of the foundation as well, and grading as well. So, and you'll see in the packet of how much money she expended in that regard. So that's really the three issues before the board. And I just wanted to, in your packet, I've included a timeline. And it's probably just interesting to see the timeline because we mentioned September 18th, the zoning board approved this. Prior to the zoning board approval, HARB had approved the architectural for the premises. The Board of Commissioners approved the initial HARB approval in September, shortly after the zoning board's decision. On October 24th, both grading and demolition permits were issued by the township. On the 27th, there was trees removed of October. 29th of October, demolition commenced. Around November 5th, demolition was completed. November 24th, a building permit was applied for. And this isn't really an issue before the board, but just so everyone's aware of the chronological.
So what exhibit are you referring to?
It's A10.
Is this in the new material?
It's in the new material.
Okay.
It's right on top, I believe.
Ah, here we go. I'm sorry.
And what happened was when they applied for the building permit, the township came back to them and said, wait a minute, you changed the architecture on this building. You're going to have to go back to HARB. So as a result, the building had already been demolished. It went back to HARB. HARB approved it, and there was some issue. They weren't happy of the fact that it was demolished, but in the minutes that are attached, they said we would approve the demolition in any event, and they approved the plans. A protestant did appear before HARB at that point, and his main gist, I think, was complaining about the demolition and the fact that it was against the zoning regulations. He then appeared before the Board of Commissioners and raised the same issue. And it was at that point that it was decided to put a stop work order on, which has been obeyed since that very time. And as you know, if you've driven by and there's photos, right now we have a big hole in the ground, basically. But we've complied with the stop work order, and that's also attached. All right, that's basically the gist of what will be going on here this evening. And the first one will be Ms. McMichael. And Carol, you've been sworn in. First, you are the owner of the property, is that correct?
Yes,
It looks like you purchased it in August of 2008,
sounds right.
based on the deed A2. And I've marked as A3, and this is a copy of the, I would ask, Mr. Chairman, actually, it'd probably make it easier, too, that the prior appeal, that the transcript and the exhibits from the prior appeal, that's 2787, in September, be part of this record as well. It is similar fact, basically the same facts, and there's the originals of the survey are in that file, and I've
Okay.
made copies of them. We marked as A3, and that was the condition or the survey when you purchased the property, correct? A3.
Yes.
All right. And then A4 was what you had presented to the zoning board regarding the footprint of the building, of the new building,
Of the
proposed building.
yes.
All right, and actually you had, you were going to demolish the existing garage. It was right on the property line, is that right?
Yes,
And you're going to move that to a conforming location,
correct.
and you were extending this side. You were extending this side property line here, correct?
Backwards.
Backwards. You were
Yes.
keeping the front was the same. You weren't encroaching any further on the front yard setback,
Correct.
and you just were extending the side yard
Right.
backwards, correct? And keeping it the same distance from the property line as currently exists.
Yes,
Okay.
So you're saying that what you wish to have approved tonight is the same footprint that was, exact same footprint that was approved by this board in September?
Yes, exact same footprint.
Okay. But the difference is, then it was adding on, and now we've got a demolition condition.
Yeah, you have a demolition condition here, and again, as I mentioned, as we'll get to it, she did state she wasn't certain whether it's going to be demolished or an add-on, in her testimony.
Okay.
And then you'll notice there was photographs that were marked as A5 of the old appeal, 2787, and it just showed the house being in very poor condition, and as Ms. McMichael stated, just in, just lack of care for a number of years. And then we've marked as A5 the actual opinion, so that you have it before the board. And then A6 is the testimony of Ms. McMichael regarding that time. And Carol, it's true, you were asked, is this going to be a demolition or replaced? And if you could read your response, which starts here, back down at line 24 on page 8. Down here.
it's being renovated. At the moment, I don't know. The idea is to keep as much of it as possible. But the building has so deteriorated, and until we get in there and start to take it apart, we don't know how much has not been destroyed by termites and neglect. It's been empty almost a year, and before that, it had no maintenance for at least 20 years. It's in rather sad shape.
I'm going to show you as what's been marked as A7. Did Mr. Bowerly, and he'll testify here this evening, did he apply for, or did you apply, or did he apply on your behalf for a grading permit?
Yes.
And when was that issued?
October the 24th
Two-
of 2008.
Okay, and did he also apply for a demolition permit?
Yes.
And when was that issued?
That was issued on October the 24th, 2008.
And Mr. Bowerly proceeded to demolish and do grading on the premises as a result of the issuance of those permits, is that right?
That's right.
Now, A9, I'm going to show you, was there a foundation permit issued in accordance with A9?
There was on December the 18th of 2008.
And initially, you had gone to HARB in September and received their approval, is that right?
That's right.
Just for the record, I just attached that as A11, correct?
That's right.
And the Board of Commissioners, they approved that initial HARB action, is that right?
I suppose they did, yes.
And I've marked that as A12. They did that on September 22nd, 2008. Correct?
Yes?
Okay. But you had to go back to HARB.
Yes.
And why did you have to go back to HARB?
Because during the time that had elapsed since the first submission was made, a great deal had happened in the financial world, and I found that I was not willing or able any longer to put as expensive a house as I thought I was going to put there. And so the plan was modified, changing as little as possible of the front facade. That was kept as much as possible the way it was originally. But there had to be modifications made because it was simply too expensive to build.
And you're talking about architectural modifications.
Yes, yes.
And again,
Nothing about the footprint, no.
And on A13, minutes from the HARB meeting, you received permission to do that.
Yes.
And at that time, they were aware that demolition had taken place and weren't happy of the fact that it was demolished before they had been brought before them, but they also stated that it would have been approved anyway because in such poor condition.
Right.
Now, I've marked as A14. That's just the letter indicating that HARB had approved it at their January 7th meeting.
Right.
And then A15 is the stop work order. Is that right?
Oh, yes.
Okay, and that basically, you were told verbally at the Board of Commissioners meeting a couple days before January 29th to basically stop the work?
Right.
Just out of curiosity, when was the last time prior to this evening or filing this application was I involved at the zoning hearing?
No, after the supervisors' meeting, where we were there to have the HARB appropriateness ratified, an issue came up about zoning by another member of the public, and the proposal was, I guess in the absence of anybody knowing what else to do, to stop work on the property. I got home, and at 10:04, I emailed Nick and said, what do we do now?
Okay. I'm going to show you just A16, which is a series of photographs. Is this basically the condition of the site as it exists today?
I haven't even been by it for weeks. I can't bring myself to.
Okay. And A17, we've marked as an exhibit and both expenditures and reliance as well as the invoices. Have you paid all these invoices?
Yes.
Could you put that under the camera?
That should be in your packet. Yeah, it's in your packet. Okay. And what was the total amount of the expenditures?
$51,987.
And I'm going to show you finally is A18. These were some letters. Is that correct?
Yes.
And these are letters of support from neighbors?
Right.
Okay. Did you believe that you were permitted to proceed with the demolition?
Yes.
Why?
Because we had a permit to do so.
Okay. All right, I have nothing more for Ms. McMichael. I would call Mr. Bowerly, unless there's any questions for him.
Are we going to have some testimony as to why the building had to be demolished, why it could not be saved?
Sure. Mm-hmm. Mr. Bowerly would be the person to testify to that. Michael, you are under oath.
Yes, I am. Good evening once again. I'm Michael Bowerly. I'm the owner of Ryan Building Services Incorporated, which was retained by Carol McMichael to bring this project forward.
And what is your occupation?
My occupation is a builder, developer, and realtor, and I've been building in Radnor Township for over 25 years.
Do you know how many homes would you say you constructed in Radnor?
I've constructed over 30 single-family dwellings within the township in the last 25 years.
Okay. After the zoning hearing of September 18th, did you have an opportunity to thoroughly inspect the premises?
Yes. A little while after the zoning hearing, Ms. McMichael called me asked me if I'd be interested in the project and to go over and inspect the property.
I'm going to mark as A19.
Oh, yeah, I believe I did.
I'm going to mark as A19. A series of photographs. And if you can tell the board, what was the condition of the house when you inspected it, and if you could tell the board what these photographs represent.
But, sir, before you start, would you mind shifting them so the folks at home can see the photos? Okay, thank you. Thank you.
Okay, what you're looking at is the right, or excuse me, from standing outside, it would be the left front foundation wall. What is exposed there?
These are all A19 as a packet?
Yes, I had marked them as A19 as a package.
Okay.
This particular photo depicts that the basement was only 7'5" deep. It was constructed of cinder block, which is no longer legal to build on or build with. And it also explicitly shows that the front wall was exploding outward into the yard. You can see where the sewer line is exiting. You can see a gap, an opening, which is actually due to extreme water damage and deterioration of the very foundation in the front.
Can you indicate on the photo where the opening is shown?
Right here.
Okay.
This whole area.
That's dirt we're seeing there?
That's basically dirt.
Mr. Chairman, if I think what we ought to do with this, since they're all stapled in the same order, is make A19A, A19B, just go right down the packet. That way, when we're talking about a photo, we can follow it better. So I'm just going to A19B, A19C.
By the way, when did you inspect this building? The date?
It was about a week or two after the zoning hearing board.
Okay.
Okay.
Okay. You want to just flip through them?
Okay. The next one shows that in the center of the home, again, was a cinder block chimney, which you can see is deteriorating on the corners.
Wait, can you, I don't see that it's deteriorating. Can you show me what you mean by that?
Shows you quite a few things, okay?
Yeah, we're going to need you to walk us through so we understand the state.
Yeah, this is
in detail.
A19B.
Yeah.
Yeah, this is A19B. This area that you're looking at right here was the foundation for a fireplace that was on the first floor.
Mm-hmm.
As you can see here, 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 there,
Mm-hmm.
there, but especially along the bottom, okay? Extreme deterioration due to water and gravity. Water finds its easiest place, and it seeps down.
Mm-hmm.
You also notice
Those dark
that,
areas are water damage?
yes, here is excellent examples of extreme water damage.
Mm-hmm.
In fact, this area right here wasn't even concrete, so it wasn't even a fully concrete basement.
And does the water damage compromise the structural stability of the house?
Absolutely.
Okay.
And then we go to, we're going to see,
This is A19C.
this can be C. Now, this is on the first floor, and this goes along with your question just a moment ago. Your question was, does this compromise the structure of the building? I think that C and its crack shows that there is an extreme serious compromise of the structure of the building.
Is that crack, in your opinion, a result of subsidence of the
Yes.
chimney foundation?
Yes. In fact,
Okay.
if you look close enough at the mantle, it's starting to run downhill, which would explain B, which would be this side of the fireplace with its water damage. Okay?
Okay.
So if we go on from C to D, okay, now we're on the first floor back left-hand corner. And you can see this whole window has been rotted out. You can see the water damage underneath the window. If you look closely at the radiator, it's leaning. The floor itself is leaning. And it's hard to tell in this picture, but there's actually a step down to go out the side door. This was the side door that would enter out onto the driveway. Okay?
Was there water damage in the house as well, in the
Oh,
interior?
yes, on every floor. Look, just look at the top where my arrow is pointing right now.
Yeah.
This is all water damage.
Uh-huh.
There's holes in the roof that were never repaired.
Okay.
This is the kitchen.
We're talking about E.
And we're talking about E, excuse me. On E, if you look to the right of the cabinets, you can see where the plaster is absolutely falling away.
Mm-hmm. And that's where the refrigerator used to be, presumably?
I assume so. There was no refrigerator there when I was there, but I would say because of the height of the outlet, that it would be presumed that a refrigerator was there. But it's depicting the damage that just goes on and on, you know, throughout the home. On F. This is the front patio as you walk up the steps. If you look to the left, you can see that the steps are falling away. Again, the foundation for the steps is so bad that if you look at the slab that goes across, it has been cracked and was falling in, as well as you can see deterioration of the wood on the handrails, the posts, and the very entry itself. Again, this is deferred maintenance that was just never done in the last 20 plus years.
And is the cracking of the slab, is that a result of subsidence?
Yeah, the cracking of the slab is just due to water damage and frost heave over the years.
Okay.
And G, we're looking at an addition that was put on, and if you look at the window above the air conditioner, the window is almost completely rotted out. Same with the window here, and you can see the addition, which is a one-story addition in this area, you know, has been compromised. This right here was the current electric service, which Radnor Township had me dismantle prior to the issuance of a demolition permit.
Was there a safety hazard posed by the electrical service before you made a decision to demo the building?
Yes, there were bare wires, there were stripped wires, there were, you know, plugs that were pulled out of the wall. You know, I didn't want to be in the building, do too much with it. You can even see, you know, look at the air conditioner right here. Okay, I don't know how old that air conditioning is, but you know the coil's clearly rotted. I mean, it's again continued deferred maintenance. And in this picture, the only thing that's
H, we're referring to
H. I'm sorry, excuse me. In H, the only thing that's really notable here is in this area. This is a baseboard radiator. You can see water damage along this. It looks like someone had made some attempts, but if you look here at the base of the water closet, you can see a crack in the floor. This would be in continuation with, you know, structural compromise of the home.
And that was a tile floor in that room?
Yeah. Okay, an I. We're looking again at rotted sills. We're looking at holes in the roof along here, all along here. We can see that this is the chimney that we're talking about that went right down through the center of the structure. You can see the water damage. You can see where it entered the home and started its flight down to the very foundation of the home, which I think is very, very clear. Also, if you look across the bottom, you can see that, you know, that the siding is either chipped, cracked, pieces missing, not properly flashed. Again, all water entry points that continue on with that deferred maintenance or the making it fall apart. And this is a repeat photograph that we already saw. You saw earlier.
J, you're referring to J.
J,
Okay.
yes. Rear foundation, don't you? In the basement, where you see the wall imploding.
Sir, did you visit this building before Mrs. Applied for the zoning change?
No, sir. No, sir. I had nothing to do with her going to the zoning hearing board the first time. I had nothing to do with her going to HARB the first time. I think she really wanted to get her affairs in order before she started looking at contractors or hiring someone.
Were township inspectors, did they observe this also?
Oh, yes.
Okay,
Yes.
is that why they issued the demolition permit based on?
Absolutely. I went into township and I told the township officials of the condition of this building, and I spoke with many of the officials in the township, invited them to go out. I think Mr. Loper will testify that people from the department went out and went through the house. When I applied for the demolition permit, in order to get a demolition permit in Radnor Township, I'm sure you know this, but I'm just going to go through it anyway, you have to show proof that you have disconnected any electric, any telephone, any cable, water, and sewer, which must be inspected by a township inspector. We disconnected the sewer. Mr. Daly of the building department came out, was in the house, watched us disconnect and plug the sewer in order to protect Radnor Township's sewer system. At that point, the demolition permit was issued to me 24th October to Ryan Building Services, and it was explicit that it said to raise the structures, in parentheses S, meaning more. There was only 2 structures on the property, and we proceeded accordingly in good faith with the building department.
Do you recall, when did you start demolition?
We started, well, the 24th, I believe, was a Friday, and we had to get our tree protection and our sill fence inspected before we could get the grading permit. That's before you can really do anything. And we cut down trees, I think, on Monday and Tuesday, which were approved to be removed. And then we started the demolition, I believe, on Wednesday, and it took approximately a week.
Now, sir, you got a demolition permit because you asked for one, not because the township recommended that you get one, right?
No, I don't believe that that's quite true. I had conversations with Mr. Malloy on this very property. I think if you look closely at the permit issued by the engineering department, there's a verbiage to the fact that that was the recommendation of the township.
But you did request it.
Yes, I did request a demolition permit.
But it wasn't suggested by the township that you demolish the building, correct?
Well, not in those words, but I went in and I told them what the situation was. I've always been upfront with the township.
I have no doubt of that. I just want to be clear that the township didn't recommend that the building be. That's not the suggestion. There's no dispute that a permit was issued. I'm just trying to understand whether it's the position of the applicant that the township recommended that the building be.
Basically, our position is that we requested a demolition permit. The township came out and inspected and determined that it was appropriate.
Okay.
It wasn't on the township recommendation that we demolish the building.
All right.
Let me ask you, was there evidence of wood rot, damage from termites, things of that sort in the wood structure itself?
Yes, there were.
Which ones?
As we went through the pictures?
Just wood rot, no termites or anything like that?
Well, as you know, the township only demands a certification of rodent infestation. They do not, in their demolition packet, they do not request an inspection strictly or precisely for termites.
So you didn't, and you did not observe termite damage?
Yes, I did. I observed termite tunnels.
In the wood?
Yeah, in the wood and on the walls.
Did you feel that, in your opinion, were the structural members of the building compromised by that rot?
Absolutely. Absolutely. Okay. But again, as Radnor Township protocol, I had TKO, pest control, come in, and a certification was given to the township, and is on township record, that there was no active work or no active damage going on, and that there was no rodents.
Yeah. So no active termites and no rodents.
No rodents. Yes, that's part of the township code. You have
no active termites.
Yes.
We've marked as A17 a list of expenditures and invoices. And was this the work that was performed by you? Actually, there was some engineering work in there, too, by Momini and Associates, right?
Yes, there is some engineering work from Momini, and there's also my work in there as well as the excavator's work.
Was there any work done after the issuance of the stop work order?
The answer to that is yes and no. Okay? No work was done to the property. But I had called Mr. Loper because I had a fear. And my fear was that if you look at this property, when you're digging a foundation, putting in a foundation, the normal standard under IRC is a 3-foot over dig. In other words, you dig the hole 3 foot larger than you're actually going to do. There was a garage that we had torn down. It was right on the property line. I elected to only go for a 2-foot over dig, figuring I'd find a real thin guy to go in there and parge the walls and make the waterproofing happen. I brought to Mr. Loper's attention that there was a clear danger of the safety, health, and welfare of the lands of Joyce Barrett, and that the garage could be in imminent danger of falling into the hole. Mr. Loper met me on the site. He looked at it, he agreed with me, and he gave me permission at our expense, at Mrs. McMichael's expense, to build a temporary bulkhead out of wood framing members to try and shore up Mrs. Barrett's garage, so that, hopefully that the stop work order would be lifted and we'd be able to get the foundation in and get it backfilled properly.
Can you just recount for us briefly the circumstances of the issuance of the stop work order?
Yes, the stop work order, which was strange to me, because, see, we had to go back to HARB because we altered the plans. HARB said they agreed with it, and they said that we should get a certificate of, what they call it, I think, appropriateness. But you can't get that certificate of appropriateness unless you come before the Board of Commissioners, who have to actually, I guess, sanctify what HARB was saying. So we were there for a certificate of appropriateness, and there were members of the public that started to speak up saying that there was all kinds of zoning issues. Well, at the time we really weren't there for zoning issues. We were there for the passage of the certificate of appropriateness. Mr. Loper had talked at that commissioner's meeting, and I believe his words were that zoning had no problem with what I was doing and how I was doing it. However, at the time, the township solicitor was, I believe his name was Mr. Blake, and the Board of Commissioners looked to Mr. Blake and said, what do we do? And Mr. Blake said, well, you have the right to table it and send them back to zoning hearing board. So upon tabling it, then a stop work order was issued, and I was not allowed to go back to maintain any of the E&S, E&R, safety fencing, or anything other than the bulkhead, which Mr. Loper allowed me to put in.
And didn't you put in some blankets or something also in the foundation to try to preserve the foundation?
We've wrapped the foundation with blankets. We've hayed them, because, seriously, the length of time that has gone since the stop work order has been in, we don't even know if those footers are any good anymore. I mean, they may or they may not have been compromised. Again, I'm not allowed to go on the property due to a stop work order, which I will not violate because I enjoy a good relationship with the township and the building department. But it's very well possible that once the stop work order gets lifted and we get in there, we may find that the footers no longer are suitable to be built upon.
Okay, you did do the footings. Did you complete the footings?
Yes.
The foundation, you only did a portion of the foundations, or did you?
No, all that is preparation.
Okay.
For preserving the foundation. We did not erect any foundational walls whatsoever.
Matter of fact, you mentioned Ms. Barrett, and one of the letters is from her asking for the zoning board to approve this. That's been marked as 18. Is that right?
That's correct.
I have some questions, if I might ask, Ms. McMichael. When did you purchase the property? What approximate month?
It was the middle of 2008.
So roughly July?
Yes, May, I think, Kathy, the deed.
May 2008?
August 2008.
Okay. And then you came to the zoning board in September, correct? 2008.
Yes, I
Okay.
think so.
Did you have an inspection of the property done before you purchased it? Normally, you're a realtor, I understand, correct?
Yes.
The normal thing is that you have a termite inspection and everything else. Were any inspections done?
I think any inspection of this property would be redundant. It was perfectly clear that it was in awful shape. I didn't need an inspection.
But you didn't have somebody inspect it to see how awful it was? There's degrees of awfulness.
No, I was relying on...
On what?
Look, I think what's the problem that's happened here, and I understand why there are some neighbors who are really upset. There seems to be an idea that I, by some kind of guile or cunning, decided to destroy this property. Well, I'm as unhappy as anybody that it got completely demolished. I had no desire whatever to take down 3 walls and dig out a basement and replace them in exactly the same place. Why would I? It was necessitated by the condition. This is a huge expense that I hadn't
Well, I realize that, but
anticipated.
I'm surprised as a realtor you didn't investigate it more. When did you engage an
Look, I'll
architect?
tell you what else I didn't do. I didn't even know it was in the Hague district, and I'll also tell you that had I known, I wouldn't have bought it, but that was my fault. I should have known that.
When did you engage an architect for the design?
Shortly after I bought it,
So that would have been sometime in August.
yeah, I think it was. I can't remember the exact date.
So you had some sort of design idea of what you were going to do because you had a footprint
Yes, and
presented to us.
we knew that part of the house certainly was going to have to be demolished because we had, as was clear from the plan that was presented, because it was a very different looking house, and the ceilings were a different height. But what was hoped was that we would at least keep the basic part of the house in place, but we couldn't.
What basic part was that you had hoped
The
to keep in
front
place?
yard and the front of the house and the two sides of the house, which are in exactly the same place.
I remember Ms. Bogosian, she did go to Harb, I believe, before she came to the zoning hearing board. So
Yes, I
obviously there was
did.
an architect involved, prior to that time, because there was plans submitted to Harb for that.
Who shot the photographs, these photographs?
I did.
And what month did you shoot them? Do you recall?
Oh,
I don't know that you took those. I think possibly David did.
yeah, you're right. I may have taken
Yeah,
another set of photographs.
They were taken, I think these were the same photographs that were taken and presented to Harb and also to this board.
I don't
No,
think
they
we
weren't.
saw
They were
these.
not, no, they were
Yeah,
not.
I
presented
don't
to
think
this
I've
board.
ever
No.
seen these.
They were not presented to this board.
Oh, that's right, because you were more concerned with the footprint of the house.
So do you recall roughly when you shot these?
It would have been, no, I can't tell you exactly.
Okay.
Can you tell us what month,
I beg your pardon.
approximately what month these were taken?
I can't.
When was the? let
It
me
was
ask you this.
before.
Before it was demolished, obviously.
Well, yes.
And between the time you purchased it and the time of demolition?
Yes.
Well, the reason why I'm asking is because the trees are still green, so it was early. It wasn't in the fall. And I'm questioning the timeline because you said you didn't get involved with it, Mr. Barley, until sometime in October.
That's correct.
And
these are not
these
my-
photos,
These are not my photos. I thought they were. They are not my photographs.
okay, so they're not your photos.
they're not my
I thought you,
photographs.
excuse me, I thought you had said you
I
shot them.
thought they were, but they are not. I took a set of similar photographs, but these particular
these-
photographs were
None of them were shot by you.
No.
Did you observe
Yes.
these conditions? You observed what is
absolutely.
indicated in the photographs?
I observed everything that you see. I observed.
And these are photographs of that house?
These are photographs of that house. That's correct.
I'm just, this puts us in a difficult situation because it's different than what we had looked at before. And we would have taken a different position had we known possibly what was going to happen then. And I'm just surprised that you, as an experienced realtor, wouldn't have actually known the condition of it and what you would have to do to fix it.
Well, I thought it would be salvageable.
It doesn't look like it from the photographs. You know?
Well, hope
And
springs
they're not even
eternal.
good photographs.
Right.
But yeah, I'm just surprised, and I think, what was it, 280-101 or something like that we originally gave, but when you tear something down, you don't necessarily get to go back on your same footprint.
Well,
I understand why it was torn down.
Yeah.
So we're
Although
sort of-
there's a number of cases, and I know you've heard them before, and, you know,
The
it's
casualty
still
cases,
good
right?
law. Well, it's not even casualty cases. They're cases that state that you still are entitled to the nonconformity, whether you tear it down or leave it up. And I have those cases. I'll present them to Mr. Ryan and to the board as well. And as we all are well aware, and even that this board has in the past granted situations where homes are demolished and rebuilt. And in fact, one was granted, I believe, a couple months ago on Sproul Road. And it wasn't in this type of condition at all. So, I mean, there is precedent. I understand the concern. And, you know, but even Ms. McMichael in her testimony stated she wasn't certain, that she had hoped that it would remain, but she wasn't certain when she had to go in and really inspect it. So it wasn't like we were trying to pull the wool over anybody's eyes there. Her testimony in the exhibit, or you have it, it says what it says. I guess it speaks for itself, whatever it is.
Can I ask Mr. Loper to give the circumstances under which you issued the stop work?
Perhaps, you know, and I hate.
We need to swear
Yeah,
Mr. Loper in if he's going to testify.
You do solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, nothing but the truth.
I do.
And state your name for the record, please.
Robert F. Loper, Jr. Mr. Monty, the stop work order was issued, I believe it was late January, a few days following the Board of Commissioners' public meeting where questions had arisen regarding the validity of the relief given by the Zoning Hearing Board back in September regarding an expansion of a non-conforming house that had been subsequently demolished. The question was vague. The question was clear enough that counsel for the Board of Commissioners suggested that the client go back to the Zoning Hearing Board for additional relief, if necessary, regarding the prior conditions that were granted by the Zoning Hearing Board.
Actually, it was not questioning the validity of the zoning board decision because the appeal period had run, and that was valid. It's more the question of whether the applicant's activities are within the scope of that decision.
Yes.
No one's questioning, I assume nobody's questioning the validity of the decision, which was never appealed.
There was never a question about the validity of the Zoning Hearing Board decision. It was just a matter of whether or not the relief granted by the Zoning Hearing Board in September was still valid as a result of the non-conforming building that was direct product of the expansion granted in September by the Zoning Hearing Board was no longer physically in place.
However, how did you issue the demolition permit, if that is the case? Because the discussion was that it was not going to be demolished. It was, as the applicant has submitted at that hearing, it is not going to be demolished, only extended.
The demolition permit was issued accidentally by the Department of Community Development, specifically because it was in a historic district of the township. It should never have been released because of that sensitivity. However, in defense of what went on, the staff was not adequately tuned into the exact location of the property and the address and the subsequent location being in a historic district. And our policy for demolition outside of a historic district is once the documentation required is submitted along with the application and everything is in order, the demolition permitted is released immediately over the counter without any subsequent plan review type period.
Mr. Loper, if I may ask, in a hypothetical situation on a property that is not subject to the HARB regimen, if a non-conforming building burns down to the ground and the owner wishes to rebuild it and comes in with a plan to rebuild the same building, how would the department handle that?
Well, Mr. Ryan, the zoning ordinance provides for replacement of property damaged by fire specifically, and it allows the owner of that property to replace this building in the exact location prior to the incident within 1 year of the calamity.
So you would issue that permit over the counter?
Yes.
How would you treat some other casualty, like being extremely run down, termite-ridden, something of that sort? Let's say somebody comes in with a building that's non-conforming.
If it is not located in a historically
forgetting all,
district,
it's outside of HARB, it's outside of anything, it's non-conforming. The applicant comes in and says the building is rotted beyond repair. We want to rebuild the same building. What would the department's position be on that?
Well, in order to advise an applicant that has a non-conforming footprint building in place, if they choose to destroy the entire property, the entire building, we advise them that they do not have automatic replacement rights for rebuilding on that foundation footprint. So subsequently, in the last 19 years that I can speak of, certain applicants have chosen to keep 2 or more vertical walls on top of a foundation as the maximum demolition allowed to a structure in order for them to maintain their lawful existing nonconformity status.
Nick, do you have any existing, the picture of this house before it was?
Yes. If you look on in the old exhibits, and it would be the exhibits from the prior decision, you'll see what at that time was marked as A5. That is the photograph of the front of the home. And then you see the side of the next one. I don't know if you have that. It would be in the old zoning decision that's been incorporated herein, but it's this picture here, Cora. And matter of fact, I think that was a picture, part of that was shown in the packet that Mr. Bowerly went over, talking about the roof and how the roof was sloped by water damage and the front porch and things of that nature. The testimony from Ms. McMichael at the prior zoning hearing was the house was constructed sometime in the 1940s or thereabout.
You have the rear of the building?
I don't believe, unless, do you have pictures of the rear of the building anywhere?
No. I don't believe so.
That's just a picture of the garage that was to be demolished. Let me see.
That's okay. Thank you. The main reason I asked, to see whether the house looked salvageable by the appearance of it at that time when we, gave you the variance approved. Okay, that was the reason why.
Yeah, it was standing.
Okay.
It was. Yeah, I would ask the exhibits made part of the record. I do have argument when that time comes.
Okay.
Could I ask a question, Mr. Loper? You said that if a non-conforming house were applied to have demolition, you would advise that they did not have the right to necessarily rebuild on that same footprint. Is that correct?
Yes,
of
in most cases, yes, yes, that,
Do you know whether that advice was provided at the time of this
no,
issuance?
I don't believe it was.
And Bob, you're the Director of Community Development for the Township,
Yes,
okay, and the zoning officer as well?
yes.
Okay.
Okay, I think now is an appropriate time for our executive session. We're going to take 5 or 10 minutes to have an executive session, so we're adjourned for the moment.
want a cough drop?
They were losing. They were losing with 7 minutes left by 2. Evidently, they were down 14.
Oh, my God.
And I heard now Chuck Bernifer just called up around 5, like 2, going over to 5, like 2:45 left.
So it could go either way.
They could go either way.
Wow.
I have tickets for Saturday, of course. You know, so,
Yeah.
which I would go anyway.
They play at Wachovia again?
Yeah.
Next two games,
This game.
first and second?
I was going to run out and listen to the end of it, but yeah.
You could have finished this case, huh?
One of us is not. We'll get him.
Kathy, thanks. Really appreciate it.
Thank you for your patience, ladies and gentlemen. We're back with the March 19th zoning hearing board and our discussion of appeal number 2807. Mr. Ryan?
Yeah, the board met in executive session, and by the way, I've got a cough that's bothering me, so if I break into coughing, I will spit it out in due course. And I shared some thoughts that I had. Obviously, the board has to decide, to what extent it agrees with those thoughts. First of all, I do not believe that the statement that something might have to be demolished in the record changes what we approved in the original appeal. We approved an addition, not a complete demo, and the matter was advertised as that, and the four corners of the order says that we did not approve a demo. We approved an addition. So my own personal view, which the board may accept in part or reject as it pleases, is that that's not particularly a strong argument. I also am concerned about an argument that there's an estoppel here. The one mistake that has been, to which testimony has been offered, is that the demo permit should not have been issued before going to HARB. Well, that problem has been cured, but what I don't think is within the estoppel doctrine is the concept that if a person pulls a permit that they're entitled to pull, the township has to advise them of any adverse zoning consequences that come from the permit. And if they don't, there's some kind of an estoppel. Estoppel is an affirmative conduct, an affirmative mistake. For example, if somebody is buying a property and they ask the township, is the officials, is the use permitted? And by mistake, the township official says, yes, the use is permitted. And the person, as a result of that, lets their due diligence period run out and their deposit goes hard. That's the kind of a thing that an estoppel is there. But inaction by a township is not an estoppel, and certainly a failure to affirmatively. The township can't get into the business. It's impossible to affirmatively look at every permit and try to second guess the future as to what the adverse consequences are. I do think there is a legitimate issue here presented, which the board will have to decide, as to whether the house would prove to be so deteriorated that it could not be salvaged, and if so, whether that constitutes a casualty for purposes of 101B. We have an ordinance that does allow you to build a house back if they're a nonconforming building or house back if there is a fire, and it says or other casualty. And I think the question for this board that's relevant to these proceedings is to decide, one, whether casualty extends to the kind of damage that was described, and whether the damage was sufficient so that, as a practical matter, demolition was the only way out. If the board does not find that, then I see this as a variance case for which the board should be looking for the normal hardship criteria, the minimum relief, and whether the proposed variance would be injurious to surrounding properties or the community. I think, Mr. Dolan, doesn't that pretty much cover what I talked about in between coughs?
It does. Thank you very much. Mr. Keneally, did you have any further comments?
I do have arguments, but I'm sure there's neighbors.
Let's hear from the neighbors, and then we'll hear the argument after that. Does anybody want to make a comment with respect to this application? If so, come on up, identify yourself, and be sworn.
Ma'am, if you'll raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth and whole truth? And state your full name, please.
Yes. Ruth Thornton. I'm going to come over here. Ruth Thornton, 221 West Wayne Avenue, Unit A3. My unit is in the back of the complex that is right next door to Mrs. McMichael's. And as such, I am not constantly exposed to the property, but for many years, and I've lived there for over 20 years, I have driven up the driveway to get to the back where my unit is and have been appalled by the condition of the house next door. And I actually thought all this time that the man who was living there was the owner, and wondered how he could stay in the house in the condition that it was in. But beyond that, the hole that's there now is the new eyesore. And I am at the point where I'm thinking, having met Mrs. McMichael's before and tonight, I really do believe that I'm ready to have a nice neighbor living next door to the complex, and that would be Mrs. McMichael's. So I am very hopeful that you'll let her go ahead and continue with building her new home.
Okay.
Thank you.
Thanks. Any other comments from the audience? Reluctant as they may be.
No, not necessarily.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth and whole truth?
Yes.
And state your full name, please.
Stephen Falk, live on 140 West Wayne Avenue, about a block or so, a block and a half from the property.
And would you spell your name?
Falk.
Okay.
This process strikes me as being surreal. It seems very much like somebody who has killed their parents and is claiming to be an orphan. I mean, there's nothing but one completely avoidable mistake after the other, and disingenuity coming out of every statement. you have unauthenticated photographs being purported to show things that they don't appear to show from the images that one can see on the screen. There's just no basis, I don't see, for granting the kind of relief, the claim of hardship that this applicant is requesting. They've done things wrong, and now they want someone else to fix the problem, and they want the neighborhood to deal with the ramifications of their actions. And I hope the board will not grant the relief that's being requested.
Okay.
What sort of, what would you like us to do if you had your say?
Well, at this point, they've left a hole in the ground, so I think they need to rebuild something that fits within the proper zoning parameters for that property. That may be a smaller footprint, whatever that is, and they should do it in conjunction with whatever the HARB would approve in the way of an appropriate impression, appropriate design of the property, so that you do not create an eyesore where there wasn't a true eyesore before. There was a property that could have been renovated. There's someone who purchased it without doing any due diligence. I'm skeptical that the person actually is going to live there, but I can't speak to that. I don't have any firsthand knowledge. And I think the board should give the minimum, or give the only relief that is required by the rules without any variances or other alterations.
All right, you're familiar with the houses in the immediate area there?
Yes.
Okay. How close are those houses built to the side yards? In other words, what's the setback from side
That
yards?
I couldn't say well enough.
Okay.
Do you perceive there to be a detriment to the neighborhood to permit Mrs. McMichael to basically rebuild on the same footprint? You think there's some harm that would befall the neighborhood of a house being built as close to the house that was previously there?
Was there? I'm not sure I could say there would be a true harm. I think there would be an injustice done to reward someone for taking absolutely no precautions to understand the rules and to follow them.
Mm-hmm.
So I don't know that there would be a true harm per se to put something back on the same footprint, but I don't think it's appropriate.
Okay. Any other questions for Mr. Falk? Anything else?
No, not for me.
Thanks very much. Any other comments from the board? I'm sorry, from the audience? If you'd be sworn and identify yourself.
Baron Gemmer. I do. Baron, B-A-R-O-N, Gemmer, G-E-M-M-E-R. My wife and I own the property at 128 Bloomingdale, which is actually at the corner of West Wade and Bloomingdale, approximately 150 feet from the property in question. Hopefully I won't get, some of the points have gone over, so I'll try and not to repeat too many. First, regarding the stop work order, there were two reasons. I was the protestant, both that delayed this meeting as well as asked for the continuance because of the less than 30 days, as well as spoke at the Board of Commissioners meeting and appeared at the second HARB meeting in January. The reason, what I spoke to at the Board of Commissioners meeting regarding the foundation, because I had found out at the January HARB meeting it was being built, or the permit was issued. To me, there were two problems with the foundation permit. It should not have been issued because as the nonconformity was extinguished, then it couldn't have been built in the first footprint, but also because the demolition took place, that invalidated the certificate of appropriateness in the approved building plans that existed. So a foundation permit was issued with no valid approved plans on file with the township. So I had two reasons to want to stop that, which is still the case as far as I know right now.
Just for the record, this board does not consider any of the HARB stuff at all.
Oh, no, I understand, but just in terms of why the request for relief was regarding the work stoppage, and the work stoppage is, whether it was through HARB or through planning or whatever, there's no valid building plans on file. Certainly regarding the demolition, yes, there was a huge mistake made. That should have gone through HARB, and at that time, if the condition was as such, then we would have had a chance to question it, because that is the purview of the HARB, at least in terms of seeing if it was structurally unsound, and we had no opportunity to even question that at that point. So we kind of lost our opportunity to say whether it should be or not. And to jump ahead a little, it was said that at the second HARB meeting in January 7th that the HARB said that they would have voted to demolish it. what you have to realize is, number one, they were not really presented with a lot of evidence, as you were with that. Similarly, it was a quote, if you look in the minutes, just Cam Lacey said that, and it's certainly my impression that the entire board would not have voted that way.
Okay. But let me stop you right there. Is it do you believe that the prior structure had some architectural or historical merit?
It was not well, no, it's not a contributing property, and I'm not saying that if proper procedure had gone through that they might not have gotten that demolition, but the point is, as the public had no chance to challenge that because it never went through the appropriate channels.
But you're not saying that we've lost some treasure of the township?
In this particular case, no, but the point is,
right.
And it was not a contributing member as far as I know, but the process needs to be followed regardless, because it's any structure in the Harb. As a matter of fact, just to go back, well, what was advertised at the September Harb meeting was an addition. And in fact, the garage was brought up to be destroyed. And the garage is also covered under the Harb, and that was actually destroyed under the first COA without appropriate notice and approval. It was merely in the comments.
I just have to say that I understand that the process may not have been, you question whether the process has been squared. But, we only can handle zoning issues, and Harb only, so for example, a discussion at Harb about zoning issues is probably, not beyond their purview, and Harb issues are, I think, beyond our purview. We're really here only for the zoning code.
I understand that. I was just answering some issues that were brought up that was characterizing what had gone on in Harb.
Okay. So let's.
Okay.
But from a community standpoint, what do you want that site to be? Do you want to rebuild it with a nice building, or you want it to be left out?
Oh, no, there's no intent. There should be a building there. That's not a question. And per what one of the prior speakers, Stephen Falk, said, and I'll go through the points, but I think it just needs to be rebuilt conforming to all zoning code.
Okay.
And so, but let me go into that detail. If you look, the property, we've already gone over, the property was purchased in August, and apparently no due diligence was done there. You've mentioned that the applicant is a realtor, but she's a broker owner. I mean, she knows real estate, and she's had Nick representing her since the September zoning hearing board. I have to object to that's not true. I represented her before the zoning board did not get back involved, but she testified until the board here reviewed. Okay, I wasn't implied that he was representing her at the zoning hearing board in September, and she had gone to the Harb at that time. So some of the other issues in terms of whether she knew or wouldn't have known, it's some reasonable person might be able to infer that she should have known or did know because of the fact that council had already gone to Harb in September for some of these issues, and certainly demolition would come up. Speaking, though, at the last zoning hearing board, when this first relief was approved, Mr. Cornelia gave the quote of Carol McMichael's response to your question specifically, is this house being demolished? And when you asked that question, Nick answered first, and he said, no, it's being renovated. Then Ms. McMichael answered with her question, which was pretty much verbatim of that. The other thing about the purchase and doing due diligence.
For the record, we don't have a tape, so we don't know whether.
I have a DVD, and I can play it for you right now.
No. I just don't know whether you said no at the same time as she testified. That's all I'm saying.
I've already advised the board, again, the board can reject my advice if it wishes, but that I'm unpersuaded by the transcript argument. It was an addition was advertised and it was approved as an addition. I'm surprised that nobody opposed this at the last time around. There was no opposition to this the last time around.
You're talking about in the September meetings?
Yeah.
I actually, just to set the record straight, I had no problem with the ruling in terms of extending the nonconformity with what took place at Harb. That was all fine. It was when the building suddenly disappeared that a series of mistakes started taking place.
Well, let me ask you then. If it was okay for the building to be as close as it was then, why isn't it okay now?
Because I do not believe that nonconformities are in perpetuity, and if you destroy the building, then of your own volition, of a deliberate demolition or through neglect and then demolition later, you lose the nonconformity.
So you have a legal problem with it rather than a practical problem.
Yes, although in the neighborhood, to me also, there's a lot of nonconformities that get created because of zoning changes, and I think it's good to see the nonconformities go away over time, and I think that is beneficial to the neighborhood to see them go away so you don't have all these hanging out.
Do you know whether your building conforms with respect to side yard?
Oh, yes, definitely.
Okay.
Yeah.
How about the adjacent buildings to
I'll go into that. Can I save
Sure.
that for a little later? Yes.
Sure,
Go into
certainly,
that. Yeah.
please.
In purchasing the building, when the building was purchased, she purchased the non-conforming side yard setback and also the condition of the building. And I would ask the board if they would have a different opinion if the old owner who had let it deteriorate came in and said, I demolished it and wanted to rebuild in the same footprint. Because to me, you purchased the condition, so you can't just all of a sudden create a hardship through the purchase. Oh, I didn't know it was like this. I get the nonconformity, but now I've created a hardship through the purchase that didn't exist before because you might have held the old owner more responsible for the maintenance. And certainly, we've seen that the due diligence wasn't here, so to me, there's no hardship in terms of the condition of the house, and whether it was through a purchase or even the prior owner. Let me go back to here. Mr. Ryan's already brought my point, too, about the fact that I don't think that the township is obligated to mention what the ramifications are, zoning or otherwise, in terms of the demolition.
The idea being we demolish our homes at our peril regardless.
Yes,
It's
exactly.
up to us to figure out what the consequences of that are.
Yeah. When I raised the issue at the Board of Commissioners meeting, Commissioner Mahoney questioned Mr. Loper regarding that, and I think it was characterized by the builder that Mr. Loper at that time said the zoning was okay. And in fact, what Mr. Loper said is that in his opinion, or not in his opinion, the policy of the township has been that the nonconformity goes away for a demolition like this. And that's when Commissioner Mahoney asked Solicitor Blake at the time what to do, and that's when he immediately responded regarding the stop work order for the foundation, as well as putting this matter back to zoning.
Yeah, I mean, the matter's fairly before us, so regardless of what was said at the commissioner's hearing, it's going to be decided by this board.
Yes. And the other issue, in terms of when things might have been known, I raised the zoning issue at the HARB meeting even in January, even though the HARB couldn't act upon it. I was hoping they'd put it in the comments, but the applicant knew about it at that time and certainly could have taken some action between the 7th and then the Board of Commissioners meeting on the 26th when it was eventually the stop work order was issued, as well as the zoning referral. What I want to hand out real quick, because there's the question about the applicability of 280-101B2, and you don't necessarily need the code on top. This has the code on top, but also the casualty definition under IRS Publication 547 and another accounting definition.
Those are not relevant. I'd have to object to that. The casualty definition is a matter of zoning law, and frankly, even though the federal government and the IRS outranks us for state law purposes, we have to interpret.
Yeah, not for purposes of this volume.
Oh, would you share with me what the definition of casualty is then?
This is rather casual. I think it would be normal English language. I don't think casualty is a defined term, but I don't think we'd be guided by, we're bound by something the IRS puts out any more than what the state of California.
Yeah, I don't think it's defined in there, which is why I ended up having to look for more guidance in terms of what it means. And typically, that's why Mr. Ryan was questioning when you were saying casualty like termites, and typically casualty is reserved for sudden events as opposed to a more gradual thing like mold, termites, rot, etc.
Maybe from an insurance perspective.
Yeah. Well,
maybe that's true from an insurance perspective.
I've also, and not that I can enter it in the record, but the research I did regarding some other zoning rulings in different areas, that's typically what they have done, but I don't want to represent that in other ways. But that's why I'm questioning if you can give me one, because that might help if you're not going to accept mine.
It's up to the board if the board wishes to accept it. All I'm saying is that the board has to interpret our ordinance under state law.
We can accept it and give it the weight that we deem appropriate to give it.
All right, well, let me just... Yeah.
And we'll, you need to give a copy to Mr. Cornelia, certainly.
This would be P1?
Yeah, P1. Thank you.
The reason I bring this up is because the casualty definition, at least used in other industries, including the IRS, in terms of when something is applicable to taxes, et cetera, and credits, is it needs to be destruction or loss of property resulting from an identifiable event. Oh, sorry, I'll slow down. A casualty is the damage, destruction, or loss of property resulting from an identifiable event that is sudden, unexpected, or usual. And it talks about what some of those are. And then it also talks about non-deductible losses, meaning they're not casualties. Progressive deterioration, which is things such as termite or moth damage, or weather over time because of roof leaks or something. And the reason I bring this up is because the Township Code says fire or other casualty, to me implying a sudden event. If it was meant to include these other things, then they wouldn't have had to bother to put the clause in. It could basically being destructed by anything, whether it was a slow drip or termites or whatever. And Matt, to take that even further, if it was allowed to be demolished due to any reason, then they probably wouldn't even need that clause in because there would be no sense to say that the nonconformity went away. So there obviously has to be some things that don't allow the nonconformity to continue.
Right.
I will leave you to weigh that and read the rest. Let me see here what else so I was going to get to the. So my position is due to the reading of 280-101B2 that it was a deliberate demolition due to some cause other than casualty, so the nonconforming side yard setback is extinguished. And to me, therefore, it almost needs to be treated as an empty lot, forgetting the fact that there's a foundation trying to be dug. That's neither here nor there in terms of the starts that went on in violation of other code.
And further, you don't believe a variance should be granted to grant the relief that was...
No, because I'll go into let me go a couple reasons there. Because if you look at the lot is conforming. It's 55 by 301, 55 being the minimum frontage required for R5. Also, it's regularly shaped. It's 55.
No, it's 50.
Oh, it's on the tax record. I'm sorry, the tax record it says 55.
It's 50.02 according to the plan.
I'd like this. Yeah, I'm surprised because I know there's another one that's 50, but that's what it says in the tax records.
This is a sealed plan.
Yeah.
It is 50.02 feet.
Oh, I'm doubting the validity of that, but it's been entered, so I guess I can't.
You can register your objection to
Yeah,
the
I do. To me, there's never been representation made that the property is non-conforming in terms of dimensional.
Well, a sealed plan is the representation by the author of the plan that it in fact is that.
Because it seems very unusual because the tax records with Delaware County go into go to 2 decimal points on the feet, and this one explicitly says 55. So I don't.
These are sealed by Kevin Momini, whose plans have been accepted by this.
I understand
board, countless times.
I understand that. Beyond that point, though, because I believe even at 50, it's still. The lot area is still 3 times the minimum requirement for a lot area in R5. So certainly if it's a bigger building that's desired, there's more than enough room to go back. There's no need to be playing with side yard setbacks if you're trying to make a bigger house. Mm-hmm. And per Ms. Bogosian's point, I'll go into what exists in some of the neighborhood.
Can I just ask a question? Is Ms. Barrett here?
I think she's away.
She's in Florida. And have you spoken with her?
She wrote a letter in support. It's in the back of the packet.
She's in support. I see. Okay. Thank you.
Yeah, well, and I actually spoke with her on one day also. I mean, part of what, it's not different, a lot different than some other situations. A lot of the neighbors are in support. They want to see something there. I don't want to see an empty lot, but also their impetus is there's a hole there, so they want to see something sooner rather than later. I'd rather see process and code be followed and then have something up. So some of them have more expedience than others. As far as I know, and no evidence was presented contrary to that, in looking at that block, which would run from, let's say, Bloomingdale to Conestoga along West Wayne, I know of, as far as I know, all conforming lots, and I guess there's a question, is this a conforming lot, have conforming side yard setbacks. And there's a couple single family homes on the other side down by the corner, 200 and 200 and a half. They certainly appear to conform. I didn't measure exact, but they look like they have at least 10 feet on both sides. And furthermore, the property at 200 and a half West Wayne is listed in the tax records as 50 feet wide, even though this property is listed at 55. So I assume it's either the same or smaller, where there's a discrepancy in the tax records on 215, and it conforms. The reason I'm saying that is per 280-145B, where you're talking about will it be the detriment of the neighborhood, will it benefit? In some ways, I think it will be the detriment, because that's the nonconformities, to me, need to go away over time if they're not cared for. But more importantly, it also talks about, let me read the appropriate, in terms of an appropriate, the presence or absence in the neighborhood of conditions or uses which are the same or similar in character to the condition for which the use, for which the applicant seeks approval. And I know of no examples of lots like this where there's a non-conforming side yard. The only ones in that entire block are across the street, where there are Spanish-looking townhomes. And so if it was a duplex, some of those, I think there might be at most 3, perhaps 2 or 3, but the entire rest of the block is conforming to all its side yards.
Well, can I just, the code calls for a 55-foot wide lot, right?
Correct.
Okay. So it also calls for 2 10-yard side yards.
Correct.
10-foot side yards. So it basically calls for a 35-foot wide building, or permits a 30-foot wide.
Correct.
Okay. They're proposing a 34-foot wide building here, right?
Well, there's still a question. To me, if it's only 50 feet wide, that's another issue, which I had no idea about, because again, I was looking at the records there. So I was thinking 35 feet per what the code would allow.
Mm-hmm.
I guess I hadn't heard prior to you mentioning it that it was 50 feet, because I would have thought that would have been brought up as some kind of hardship as a non-conforming lot.
Well, when the prior application was made, it was a 281-1B1. So.
No, I meant to even during the meeting today.
He has asked for a variance in the alternative.
Well,
but I interrupted you.
No, but that's okay. Well, that's fine, but I hadn't heard the hardship yet.
Sure.
So if that was the hardship, it hadn't been claimed.
Well, he's going to give us argument later.
Okay.
Well, just so if we only had 50 feet, and then we have to go with 2 10-yard side yards, then he's only got a 30-foot wide building when the code permits a 35-foot wide. I'm having some trouble.
No.
I understand the concern with the process, and I understand the concern with at least the perception, and I don't think it's unfounded that perhaps there was some knowledge beforehand of the situation, but we're on this board and we're stuck with the code and we're stuck with the numbers and trying to understand that and trying to make a practical decision based on what the numbers and the setbacks are.
And that's what I was trying to do, obviously, with different numbers than you were working with.
Right.
With that said, certainly if the property is non-conforming, if it's 50 by 301 indeed, then that's a different issue. Perhaps there is perhaps a hardship there, and some variance is warranted in that case.
Okay.
But that's not what I've seen to date.
I understand you relied on the tax information.
Let me just see if there's anything else here. So just to reiterate, as far as with the exception of the townhomes across 2, possibly 3, because they are on very narrow yards, they aren't even come close to conforming in terms of the twins that are across, the 3 twins that are across the street. I know of no other non-conforming side yards in the entire block on either side.
Okay. So. Do you know of any side yards that are at or about the 3.25 feet, 3.5 feet that they're proposing? I mean,
in that neighborhood?
In that neighborhood, yeah.
No, because even the ones that I'm referring to across the street are at least 5. I don't know where the property line ends,
right, but
there's at least 10 feet between the building, if not more.
I'm thinking of the distance between the twins.
They're at least 10 feet, if not more.
Okay.
Oh, yeah. Yeah, but if they obviously would need to be 20 if the property line ran down the middle to have the 10. Right. So that's
right. But they're further than 3.5 feet.
Oh yeah, they are further.
Yeah.
Oh, much
okay.
Yes. Well, again, I don't know if the property line is real close to 1 and 7.
I understand.
7 and 3.
But if we're going to average it, they're probably further away.
They're
than
at least
3.5 feet.
5, if not 7, okay, or somewhere in that ballpark. And I believe, at least for the moment, I think that's all I have. Thank you very much.
Okay, certainly. Does the board have any questions or comments for Mr. Cameron? No? Thanks very much.
Thank you. response to Mr. Gemmer, I'm sure as other people may talk too. The deed that's been marked as A1 actually refers to the width being 50.02 feet, which is this, or A2, excuse me. The deed refers to 50.02 feet, which is exactly what shows on the survey. Also, remember there are twins in this area. Granted, they're conforming, but they're twins, so they have 0 side yard setback. And all we're asking for here is to continue the existing nonconformity and actually made it better by removing the garage, which was right on the property line, and making that conforming as well. But that's just to, I still have some argument.
Certainly. Any other comments, sir?
Sir, if you raise your right hand, do you solemnly swear or affirm the testimony you're about to give will be the truth and whole truth?
I do.
And state your full name, please.
My name is Joseph Ellis. I live at 221 West Wayne Avenue, Unit A1 in the front. I face the front, and my side windows face the subject property. I can't speak to the procedure, of course, for some of these technicalities, but I fully support the proposed project that Ms. McMichael is presenting before you. I've lived at this location for 5 years. The previous resident was a tenant who ran a landscaping business from his property. He abused the house as well as the property. So as a neighbor, and I'm an officer of the Homeowners Association, where I reside at 221, there are 8 units, and we support what's been proposed by Ms. McMichael.
And do you speak on behalf of the association tonight?
I believe I do.
And
well, the two, Ann's an officer as well, and Ruth is also an officer of the association.
And you personally have no trouble with having a building put on that lot that's 3.5 feet from the side yard?
Not at all.
Okay.
It'll be an improvement, in my opinion, an improvement to the neighborhood. What was there was never maintained, and it was abused, both the property and the house.
Okay. Thanks very much. Is there any comments or questions from Mr. Ellis? Thanks, sir.
You're welcome.
Ma'am?
I do. Ann Ryan. As Joe said, I live at 221 West Wayne Avenue. I live in B3, which faces the property. My front door faces this property. And for years it was, in terrible, terrible condition. And the first time I got to see Ms. McMichael's plans was at the HARB meeting. And, they were beautiful plans. They were in keeping with the neighborhood. That was actually determined by HARB. At least that was my impression from what HARB said. And I just feel that it would be far better to have this house approved than to have a hole in the ground. And I also think it's far more important to consider the opinions of the neighbors who live adjacent to the property, such as Mrs. Barrett and myself and the other members of 221 West Wayne Avenue, than someone who lives way down the street. Thank you.
Okay, thanks very much. Any other comments or?
Can I be heard again?
Let's let other folks be heard first.
Oh, is that my wife that was trying to speak?
Yes, I do. Elizabeth Otwell, Otwell, 140 West Wayne Avenue. I want to speak a little bit about the process here. I feel like when my husband and Barron spoke that there's really kind of an almost dismissive attitude, and that what we're going to end up with is Radnor approving another whatever a real estate agent wants to do. And the implication that this lady bought a property and she didn't know what kind of shape it was in, I don't understand how you can all swallow that. And I really believe that Radnor at this particular time owes it to its citizens to observe the letter of the law, that there's none of this smudgy-wudgy stuff. if the township says when there's not a building there, you should observe the setback, I think that's what we should do. Thank you.
Ma'am, the idea is that the setback would be observed unless a showing were made of that variance relief was appropriate or that special exception relief was appropriate, and that's what we're considering.
That's right.
Yeah.
And there's not a house there now. The house is gone. It's an empty lot.
Right.
So if you go to build a new house on an empty lot, you have to observe the restrictions of that lot.
I'm not sure that's the only issue here.
Unless
You're right. There's another issue. A property was torn down illegally, and I think she should be fined.
Permits were issued and the property was demolished in accordance with permits.
And I'm speaking, I have the floor. We have listened to you talk for an hour over the condition of the property that the lady bought. She knows how to buy property. It was in bad shape. It couldn't have been a surprise afterward. It was torn down knowing, and it was bought knowing that she was going to tear it down. I believe that matters.
Sure, it matters. It's a fact that we're considering. But
I see how much you've considered it.
Well, we haven't made a decision yet, ma'am.
Okay. Looked to me like you had.
Well, is there anything further?
No, do you have anything further?
We'll see.
Okay,
Thanks very much.
Thank you.
Sir, did you want to say something?
I did. I think given the nature of the testimony that's been heard from the applicant and the whole process that's been followed by the applicant and frankly the applicant's behavior even before it got before the various township entities and bodies, that it might be useful to have that property remeasured. You have a document that says a certain dimension. You believe it because the person has provided other documents that in the past have been taken as trustworthy. The township or county's own records seem to show something different. I think that given the behavior of the applicant, the comments of the applicant, and the applicant's witnesses, I think that it would be useful to have that done by another person, another party. Could turn out to be entirely accurate, could turn out to be inaccurate, but it seems to bear a little bit on the issue that you're going to be deciding as to whether or not relief is necessary and should be granted.
I'd like to respond to that. I've found that the county tax records are frequently not accurate on something like that.
I'm sure that could be.
And this was surveyed by Kevin Momini recently. He even has trees on here. And I think we can trust what was said on this.
Also, the deed has the
also.
deed governs. I mean, whatever was conveyed in the deed was what was conveyed in the deed. That's the end of the discussion.
Wouldn't it be relevant what's actually on the ground? I mean, I'm not saying it's necessarily wrong, but wouldn't it be what actually governs is the number of feet between the two properties on either side?
The deed says 50.25 feet. It doesn't say 55 feet. If the deed says 50.25, 5 feet or whatever it says, then that's what that was what was conveyed.
It's a different issue, but I understand your point. Okay. I have nothing further if you don't have any comments.
Thanks. Any other questions for this? Thanks very much. Anyone else?
If I could request a grieved status on the basis of a township-wide issue, in addition to my standard claim, which is a valid one, as being quite a buff of architecture, a daily or twice or thrice weekly user of the street.
He's already been sworn.
I think, first of all, you need to be sworn in. Was he sworn in in a different?
Oh, you're right. That's right.
Different appeal.
I do. James Schneller. In addition, the matter of my aggrievement is is before the Commonwealth Court. I challenged a prior ruling, and that actually occurred after a zoning hearing board meeting. And I believe it's appealed for valid reasons. And I especially just wanted to make the point that
if I may, again, to the issue of standing, I object to Mr. Schneller participating The Court of Common Pleas has already determined he did not have standing in a matter that was closer to where he lives than this particular property. He lives over a mile from this property. For that reason, I would object to his right to standing in this case. As I said, the Common Pleas Court has already determined he did not have standing. He raised it again on another issue, on the subdivision, on the Harb issue of that. Again, the court said he did not have standing, and he is right. He did appeal that to the Court of Common Pleas, or to the Commonwealth Court.
Mr. Schneller, is it true that you're located 1.25 miles away from this property?
It's nearly a mile.
More or less?
I would say the difference between the other property, less. However, that's measured to the other property. It could be that this additional 500 St. David's Park condos at St. David's Ave and Lancaster Avenue. Believe it or not, it is a. If I went through the legal questions I've raised, and I'm not an attorney, but they're extensive, and if the board could accept, because I simply have one sentence, could accept the fact that I've made a tremendously valid argument in the Commonwealth Court.
Sir, just let me interrupt you. We're not here to debate standing. Let's hear your comments on the merits of this application, and very briefly, and then we can move on. It's after 10.
Thank you. And just to say what I was going to say.
Just very briefly. Thank you.
If I could finish up on aggrievement, and I know the board doesn't, quote, take into consideration any HARB type of criteria. However, the HARB expands my aggrievement simply because of the fact that I am an architecture buff, and the zoning law in general entails the comfort of citizens, and that includes their environmental surroundings. And if a HARB is in force in this township and in this section, and I live in that HARB or across the street from that HARB, this expands my aggrievement, I hope, for the board's satisfaction. My only point is that the township is currently in a state of stress, and this board is the fact-finding body. This is all we have. And what's happened is there is feasibly misrepresentation in the prior proceeding. With all respect for everybody, there is a large question of possible factual error to the point of needing correction. And at the same time, we have community development whose manager overall has been admonished in some way.
Well, this is not at all remotely relevant.
It is because your prior decision is in serious question.
It was a 280-101B1. The question is, I guess, as I understand your issue, is did Mrs. McMichael know at the time she made her application that she was going to demolish the building? She has testified under oath that she did not know at that time. Now, we are free as a board to accept or reject her testimony based on our finding of her veracity. But to get into other issues aside from that testimony with respect to township officials, from my perspective, is wholly inappropriate.
Well, I'm, with all respect, I think they're intertwined. And I think that the board might please take a look at it, because there is the matter of the prior decision being severely compromised. Therefore, the matter is continued. The violation may have continued, and
Mr. Schneller, you need to understand one ironclad legal aspect. The prior decision was issued, it was not opposed and not appealed. Under Pennsylvania law, it can't be challenged anymore. That's very clear law. I'm telling you, once a decision is issued and it's not timely appealed, I personally believe it was a correct decision at the time, and the question is whether what's happening here is within that scope. But it really is not something that this board, even if it wanted to, could indulge in as a critique of the other decision. The decision's done and it's final, and it's beyond challenge under Pennsylvania law.
I believe fraud, though.
No, Pennsylvania. No, I can assure you, the decision is honestly beyond challenge.
I wouldn't suggest a challenge or a citizen's challenge, although it's feasible, but I know that fraud in general could be a reason to open it.
Do you have any comments regarding whether or not the the construction of a building 3.5 feet from the side yard poses a detriment to the neighborhood? I mean, let's talk turkey about the merits of the application as opposed to the process. And okay, what is your view?
I have a sole, in addition to agreement with everyone who's spoken, and the fact that there are apparently mostly conforming, if not all conforming side yards. If you look at the property adjacent, which apparently is a 4 or 6 unit, it is a spacious lot because it is a cluster home. And then if you look at the lot next to that, there is a nicely renovated home right next to Adelberger's. Now, the other side of the cluster home is this lot, and I certainly plead with you to provide, however nicely, for a side yard there, to keep the block attractive, to keep property values up. Thank you.
Okay, thank you. Are there any other comments from, ma'am, please?
I'm sorry to be late. I was watching Villanova.
Are they winning?
They won.
Yes. All right.
Right. Yeah. Oh, yes, as far as I see it. My name is Cheryl, Cheryl, Tumola, Tumola.
If I may, Cheryl, where do you live?
I know where you go.
Okay. Where do you live?
I live on Midland Avenue, 411 Midland Avenue.
Okay.
And you would say you're probably a mile away from the site?
I think it's 1.2 miles.
Okay.
Same objection?
Same objection.
Okay.
I am also the head of the civic organization for this area. I'm sorry. I'm so sorry.
Try to speak directly into the microphone.
I'm head of the civic organization that covers this area.
South Wayne or West Wayne?
Wayne Public Safety Association covers everywhere from Conestoga Road to, I think it's Radnor Chester Road, Lancaster Avenue. That's kind of a triangle.
You're not appearing here for the Civic Association?
No, I'm just
You're
making it.
appearing here as an individual?
I have one line.
Okay.
One line. Oh, I have one. I will do my best. I don't think this has any detriment to the neighborhood. 3.5 feet is probably what John would consider de minimis. But I think it has a lot to do with the way that we all address what the code is supposed to be doing for us, and our faith in the fact that we must follow certain rules. I know that when I put an addition on my house, it was 2.5 feet. My first attempt at putting this addition on was 2.5 feet over the line, and the colonel was the head of the, I don't know whether anybody except Kathy remembers the colonel, but I was denied because it was 2.5 feet closer than it needed to be, you know, within the 10 feet setback. So I think that we all have a certain faith that we're all going to follow the same rules, use the same rule book. And I think that this kind of flaunts that, this whole, what has transpired with this, and I'd like to see you kind of hold somebody to the letter of the law. That's all I have to say. Thank you.
Cheryl, could I ask you, what would you, if you were us, what would you like to see done here?
I think, first of all, I like the suggestion of having it remeasured, because I know that that's another whole step, and you know it involves whatever. But there have been several cases where things are kind of a little, you know, if you have a map that's an aerial map, or you have someone who there isn't really a monument there, there's all kinds of confusion about exactly how wide a property is. If the county has 55 feet and someone measures it and has 51 or whatever, what's 51?
50.02.
50.02, right. There's enough of discrepancy there that would really affect this. And
Well, let's assume that 50 feet is right.
Right.
What
50
would,
feet
what
is
would
right-
you suggest?
That they could build on the same site that they had before, essentially. I mean, I think that's being
what they're doing.
generous. Without the extension. I think that would kind of fit in within the framework of the neighborhood, have the same rhythm that existed there before.
Well, right now, what they have on the plan is 50 feet.
Yeah.
And they have a 12.3 setback on one side and about basically a 3.5 on the other side, which is 15, leaving a remainder of about 34 feet. If the ground is 55 feet wide, they're going to have an extra 5 feet there because they're building a 34-foot building.
Right.
But you've been on the planning commission and everything else. You've seen Kevin's plans for years. And this was done and prepared. He even has trees on here, which makes me think he was there, or one of his employees were there. And there are indications of pins and monuments. So there's no reason for us to doubt this plan or the deed for that matter, but I've seen a lot of errors on tax codes in Delaware County. My particular old property was one that had an error on it. So I know errors exist on tax properties. But if it's wider than it is, then there's an extra 5-foot side yard there somewhere.
Right. Right. I still think, given the climate, I think that we have a desire to err on the side of being exact. I think that that's an important thing. I think we all have to cross our T's and dot our I's, and that's what I think would be the most judicious way to handle it, considering you're a quasi-judicial body.
But initially, if 2 walls had not been torn down and they were going to build on, in other words, what we've sold first time around, you had no objection with that plan?
I wasn't even aware of it. My mother died that week. I really had no idea. Right.
Okay. Thank you.
Sir, briefly.
Baron Gemmer again, and for argument's sake, let's say that it is 50 or 50.02 or whatever. Per what was advertised in terms of building back in the same footprint, that I would still have a problem with, but in terms of the house being 34 or whatever odd feet long, perhaps the 10 and the 5 or something like that, I still have a problem with keeping it the 3.62 given, because again, if you look at the rest of the neighborhood, nothing is that close.
So you wouldn't have trouble with them moving it over?
No, if in fact the lot is 50 feet, so yes, it's a non-conforming lot, then perhaps 10 and 5 or something, which make it, because you mentioned there's 5 feet, we don't know which side they're on, so it could end up being 15 and 3.62 if there's an extra 5 feet there that's not being accounted for in the plan. But
since you guys have a hole in the ground, is that something that?
We already have the foundation, according to the permit, we have the hole in the ground and the foundation, and the footings.
I'm going to object to that, though. I'm going to object to that.
Mr. Bauer already testified. Yeah.
Oh, no, I'm going to object to why that was in there, because another thing that the applicant asked for, because of the garage perhaps caving in, was to put in the foundation in violation of zoning code with the promise to take it out if you didn't grant relief. And
That's not before. That was.
No, that was just recently.
That was
Let me finish my story.
It was not done.
I didn't say it was done. I said the offer was made, and I objected to that when it was brought up for the commissioners outside of a Board of Commissioners meeting, because I didn't want that to bias you in any way because a foundation already be there and you perceive that as the hardship.
Okay.
No more than I wanted a hole in the ground that happens to conform to the old footprint to bias you when a permit was issued in violation, and we didn't have a chance to object to that either.
But you said you objected to the. I'm just confused because it was certainly not a public hearing, right?
It wasn't. No, it was a public hearing, but I was made aware of that, and I expressed my opinion that I did not think that was a good idea, both in terms of perhaps biasing this board, as well as purposely violating an ordinance when a legal and simple remedy would have been available in terms of just doing something more, buffering up the garage. But the fact that the hole exists, Mr. Keneally is using that as an argument in terms of hardship, and again, we didn't have an opportunity where we should have with the HARB to object to that, so I object to that being used as this is where the foundation should be.
Okay. You disagree with it, okay, as a basis for hardship. I think what he's saying is that it's not practically possible to shift it over 18 inches because it's already been built.
It hasn't been built, there's just, well, you speak that.
I'll let Mr. Keneally say it.
The footings are in and the hole is in the ground. There's been expenditure as a result, and probably Michael can testify better as to what's been done and what hasn't been done. But the point of the matter is the whole 50-foot and 55-foot issue is a smoke screen, and the deed says 50 feet. And that's what he relied on. I mean, what more proof do you need except the deed says 50 feet? You have a registered engineer doing a survey based on that. Secondly, the immediate neighbor who this affects has no objection and, in fact, is urging the board to approve it. So, it seems like it's an issue to cause pain to the applicant.
That is patently untrue.
You cannot speak at the same time.
Just like the continuance last time was to cause pain to the applicant.
That was another code violation. They submitted it. Mr. Ryan will attest. It was submitted 23 days prior. It needs to be submitted 30. We keep seeing rules being bent. So yes, I'm going to make the rules.
Wasn't bent. I mentioned that to the board and the applicant voluntarily continued the meeting.
After I had an attorney submit a letter to that effect.
That's correct. It did not affect the advertising or anything else.
So we can bend whatever rules if it just happens to.
No rules were bent.
Yeah.
What rule was bent?
No,
here?
they were. It was attempted to be put on the February meeting without proper minimum time before the meeting.
Well, actually, for the record, had he done that, it would have been a big mistake.
Oh, I understand that.
So we wouldn't have, I mean, it would be pointless. I mean, my point is this. It would have been pointless for him to try to get something in under that because it would have meant that he would have gotten assuming he would have gotten an approval, it would have been void ab initio. So
I understand.
why would he, I mean,
but
that kind of accusation doesn't even make sense.
But the accusation was I brought that to the attention to cause trouble. No, I'm bringing it to attention because there's so many things that haven't been followed here. I wanted that to be followed also.
Yeah, and I think, frankly, in terms of the process, that since I represent the zoning board and in theory know a little bit about zoning law, it's up to me to make look at the letter and make my recommendation, which I did the instant I got it.
Oh, and I wasn't questioning.
I
wasn't. No.
Let's move on from this area.
Mr. Kinney, I was saying that, forgetting the 55, I was talking about the 50 case and saying that if that's the case and it's 34, then perhaps 10 and 5 would be appropriate, given that it's not a full frontage that. If we believe the 50, but then the argument is being made, but we already have the hole in the ground, and I object to that standard being used, that we should be putting it there because we had no opportunity to deal with that at all.
Self-created hardship idea.
Yeah, it's a self-created hardship. Because I made the argument that the applicant either knew or should have known a lot of these things along the way, so that and the reason I brought the other story up about putting the foundation is that would have even more severely even indicated a hardship if they brought it up. So if it is 50, then yes, I think some might be warranted in.
Okay, but not 3 3 3/4, 3.5. I get it. Okay, sir.
Yeah. Yes, I'm still under oath. Okay, I'd like to clear something up and make it inherently clear. Okay, we had a special meeting with Mr. Miller and Mr. Daly. And the gal, Peggy, I believe her name is, where they were going over our plans. I had submitted plans that were different than what was originally approved from HARB. Architectural plans. So at that meeting, I had asked for a foundational permit to put in a foundation. I was told that they would have to go back and speak to zoning or to speak to Mr. Loper. Mr. Loper called me the following day and told me that a foundational permit can and would be issued with a condition, a very strict condition. Mr. Daly wanted Kevin Momini to create a new plan, a supplemental plan that was attached to the foundational plan that showed exactly, precisely to the inch of where my foundation was going to be placed. Mr. Daly inspected that and allowed us to lay the foundation. The foundation is there, and it has been re-verified. So now we have a
Actually,
deed.
let me just ask you, was that attached to A7? Is that?
Yes, yes, it is. Yes, it is. It's attached to A7. No, this
Dated December 16th, I believe?
Yeah, actually, but you have the wrong cover
I know,
page.
exactly.
It's supposed to have the foundational plan. These were two plans, okay, that Mr. Daly and Mr. Loper can certainly testify to, that they wanted to have control. They wanted to know that the foundation that I was going to install would be exactly to the inch where the original foundation. It was inspected. We had an earth grade inspection. We had a foundation pouring inspection. And we had a third inspection. So I find it upset to hear somebody say that I had an illegal permit to put in a foundation. I say to you that I had a legally issued permit. I would never do anything illegal in Radnor Township. My reputation means more to me than that.
What would be the effect if you had to remove the footings and what's already been installed?
It would be in excess of $20,000. Okay. Which the ball has already been started.
Sorry. We cannot have outbursts from the audience. Thank you.
In my humble opinion, right, the mere fact that I was given a foundation permit, I was putting in a foundation. It wasn't until later on that I was forced to stop work. So I say to you tonight, the foundation is in, the footers have been laid. We have not one but 3 surveys from Kavamamani stating that it was done properly and correctly. Plus we have Mr. Daly, who inspected on 3 occasions, and we have Mr. Loper, who approved the issuance of the permit. So therefore, the permit was valid. What I did was valid. I did nothing illegal. Thank you.
Any other comments or questions from the audience? Peter? Yeah.
I have a question for Ms. McMichael. The demolition permit was issued on the 24th of October. You were before us, zoning hearing board, on the 18th of September. You were before Harb on the 13th of September. When did you settle on the property? I don't remember.
It's August.
August 15th.
August 15th.
From the date you settled till the date that you started demolition, was there any change in the condition of the property?
Change.
Did the property deteriorate in any way between the day of settlement to the day of demolition?
Well, I'm sure it did. It was a...
Was there anything visible to you that caused you to go to demolition that you didn't see on the 15th of August?
No, I'd like to repeat. I didn't expect that it would be demolished. I know very well that as much as a lot of it would have to be, that some would remain. I intended for it to. I wanted it to, for the reasons that I gave earlier. This was a very unpleasant surprise for me.
Any other comments from Mrs. McMichael?
Yeah, Mrs. McMichael, is it possible you can go back to the old footprint? Can you go back to the old footprint? That means you move that one side of that footing towards the center of the building so that at least the community can feel that you have extended the building to the unexpected, the demolition and all those stages which were not.
Obviously, anything's possible. But what you've heard, Stephen, you heard immediate neighbors have no objection to this. You've had, Mr. Gemmer would testify, he rents that property that he's talking about, West Wayne Avenue. He doesn't live there. You have 2 people who are in the area who have objected to it, who can't even see the property from where they are. We also have significant expenditures, and I'm going to get into it, argue. I know Mr. Ryan's offered one opinion, but in all due respect, the case law shows something entirely different. Also, the case law shows that you have a constitutional right to a nonconformity, and whether you demolish it or not, you still have that constitutional right. And I was going to hand up the cases. I'm sure Mr. Ryan's familiar with some of them, Treadle and Money and, a couple of the other cases. And so that's going to be, where we're coming from here. I mean, anything's possible. Could she build it? She could. She's out $50,000 plus another $20,000 to remove the footings and the work that's already been done. It's a great expenditure. And I know that everyone keeps on saying, well, she should have known. She's a realtor. There's case law that you do not have to know the law. She relied on good faith, as did Mr. Bowerly, on the issuance of the permits. 90 days after the issuance of the permits, that's when we get a stop work order. The time for appealing the permits had already expired. So she acted in all good faith and due diligence. I mean,
No,
that's
Nick,
the problem.
if I buy a property for that much money, $305,000, I should have checked the property for its validity, how much I can save, how much I will be demolishing. Okay, it is not
Well,
a
obviously she
joke.
bought it for that price, assuming that she would be able to put an addition on it or expand the building. It's a very small building as it was, as existed.
Or I believe that the side yards are the same as what the original building was.
Yes.
It's, they are not expanding beyond the side. They're
It's
going
extending back, but you
Yeah.
can't even see that from the street.
And that's what we granted the first time around. It was,
Yeah, I mean, what they're expanding back, and you can't even observe it from the street. I think well, I'm not going to get into what I think, but.
Any other comments or questions from the board?
No.
Nick, if you want to make your argument.
I'm going to hand up to the board a number of cases. And the first argument I'm going to address is the issue that we've just been talking about and I just mentioned, and that is the right to demolish an existing nonconformity. The cases that I've presented, Treadle, Amica Oil, and Money, all stand for the proposition that there's a constitutional right to a nonconformity, whether it's a nonconforming use or a nonconforming structure. That as a constitutional right, you have the right to demolish that nonconformity and still build, provided you're not increasing existing nonconformity, just like we're doing here. You had a building here that had the one side yard was a nonconforming side yard. We are maintaining that same nonconformity, and matter of fact, the width of the house, even though we could go wider on the other side, we're keeping it the same and going straight down. I believe the setback is 10 feet, and I believe it's 12 feet on the one side yard. So we're not even, yes, 12.31. So we're just really extending where the front is remains the same. It's just being extended back. It is absolutely no hardship at all to anyone. And what is happening here is being extended back. As I mentioned, Treadle involved basically a demolition of a shed, I believe, on a golf course. And what the court stated there, the Supreme Court of Pennsylvania stated, as I mentioned, that you had this constitutional right to a nonconformity, and that you don't lose by the fact that you demolish it.
But there is an ordinance. I mean, I have to say, I'm given these cases at 10:30 at night, and I'm not really in a position to respond to them. I just read Treadle. Treadle, there was a zoning ordinance provision that granted a zoning board an authority to make that decision, and it was upheld.
Right.
It's not founded on an absolute right, and I do know that nonconforming reconstruction can be limited. For example, the Radnor permits a 100% casualty or fire restoration, but cases have said that you can have provisions that say if it's 2/3 destroyed, then you have to build in conformity. So there's not an absolute constitutional right to rebuild non-conforming structures. It's a creature of the ordinance.
If the ordinance states and forbids you to rebuild. And that's what the Treadle case stands for. And if you look at Treadle, the ordinance is very similar to the Radnor ordinance.
But isn't Treadle a use case?
It's a structure case. It refers to use, but it's actually whether it's still a structure.
But that's
exactly it says use when in fact it's a structure, though.
Nick, that's exactly my point. I think that the ability to reconstruct in this case depends on Radnor's ordinance, not on an absolute constitutional right that regardless of what our ordinance says, they can tear it down and rebuild and still fall within an approval that talked about an addition.
And what Treadle says, again, is very similar to the Radnor ordinance. It says that unless the ordinance states specifically that you can't demolish and rebuild, that you're permitted to do it. And in this instance, if you look at it, it talks about the ordinance is very similar to the Radnor ordinance when it talks about casualty and things of that nature. It refers to casualty, and it says the ordinance, again, it says, if you look on page 2 of that opinion, any nonconforming structure damaged by fire, flood, explosion, or other casualty may be reconstructed and used. I'm sorry, Norma, I forgot. That any nonconforming structure damaged by fire, flood, explosion, or other casualty may be reconstructed and used as before, if such reconstruction. And what the court said there is that doesn't specifically forbid the reconstruction. Therefore, they had the right to reconstruct. And the other cases go in that same regard. Both Amoco Oil, which really was the first case, which stated the raising of a nonconforming use, again, it refers to use, although it was a structure, does not eliminate landowner's right to continue the present use. And then Money, which you've heard before, was presented to this board before, again, states that the ordinance must specifically bar the rebuilding of a raised structure. And this board has granted this relief in the past. Again, as recently as a couple months ago on Sproul Road, and that house was completely demolished and I think placed in a different location.
I'm reading Treadle, and as I read it more carefully, they went to another section of the ordinance. Now, the Supreme Court actually reversed the Commonwealth Court, but the Commonwealth Court in this case did not think that dilapidation was a casualty, and then instead they went off on another ordinance provision that gave the zoning board the authority to approve expanded or changed as permitted by the zoning board. Presumably they're treating that as a special exception type
exactly
ordinance.
Like we do, just by ordinance, that if you're going to extend the existing nonconformity.
But this is not standing for the proposition that there's an absolute right, constitutional right to rebuild nonconforming structures. That is very heavily influenced by ordinances.
Yes, right, absolutely.
We have to be guided by how Radnor's ordinances speak to that.
And in this case, and that's why I presented Treadle first, is that the ordinance almost paraphrases the Radnor ordinance, the ordinance in the Treadle case. Now, and it says it has specifically forbid it, and the Radnor ordinance does not specifically forbid it. Moving on. The next issue, obviously, is the vested right issue. It's not really a variance by estoppel, John. It's a vested right. Variance by estoppel would be if, I believe, by inaction would be a variance if the township did inaction. In this case, it wasn't.
Actually, affirmative action variances by estoppel and mere inaction are not
there's basically, if you look at the cases, again, I've had a chance to review it, and there's variance by estoppel and vested right, and I believe there's one other, but they were saying the only difference really in the proof is just how it got there, whether it was based on the issuance of permits or just inactivity or something of that nature. Estoppel was by inactivity. But the point here, and I think you know, that Petrosky controls this. They look at 5 standards. And the point with Petrosky, it talks about due diligence and good faith. And what it says on due diligence is you don't need to know the law. Because you don't know the law or should don't know the law doesn't mean you weren't exercising due diligence. And that's what Petrosky stands for. And the other cases I hand up basically state the same thing. And in this case, She acted in good faith. She didn't make any misrepresentations to anyone. She acted with due diligence. She's not required to know what the law is. And she acted on the fact that she received these permits.
The Petrosky, that one I do remember, that was one where she asked the applicant, who inquired of the township, is my use permitted? Is existing use permitted? They said yes. The applicant spent money and reliance on that, and the township turned around and said, well, we were wrong, but if you'd read the zoning ordinance and looked at the map, you would have figured it out. And in that particular thing, the court said, no, township, you don't. You made the affirmative statement, and you can't get out of it by saying, well, we screwed up, but you should have, caught us. And I think in this case, as I've, advised the board, the consequences of pulling a permit and doing something, the township is not obligated to advise what those, of any possible adverse consequences. But one thing is if the township had said, yeah, this permit is perfectly fine and a step of building in accordance with that decision. But I've heard no testimony as to the demolition permit that said that the township gave assurances that after demolition they could have built in accordance with the variance.
If that's the case, then you're talking about whatever permit the township issued could always, 10 years from now, someone can come back and fight it. That argument, that's what you're saying. That's not what the case law says. The case law says, just like you mentioned that the township said, you do have the use. In this case, they said you can demolish. They gave them the permit to demolish.
Yeah.
And I'm not trying to point the finger at the township because they didn't do anything wrong. The fact is, they gave the permits were issued properly, and as a result, they relied on the permits and expended over $50,000. I'm not pointing the finger saying the township did anything wrong. The fact of the matter is, obviously, a neighbor complained, and the township said, whoa, wait a minute, let's go back to the zoning board and make certain that what we're doing is right. And probably, again, rightfully so. It probably was the right position to take. Again, when you're talking about the next case I presented was Three Rivers, the Three Rivers Youth case. Again, full disclosure on part of the applicant. Permits were issued. They come back and say, oh, no, the permits were issued wrong. They're not allowed to have that use, just like the type of case you were describing. The court said, again, the Commonwealth Court in this case, said, no, you can't do that, that they relied on these under Petrosky, you must grant it as a vested right. And finally, just the Marovic case, and I put that in there because they talked about balancing the 5 standards. You don't have to necessarily meet all 5 of them, but you have to balance them. Finally, as to the variance request, if you decide that you don't want to rule or determine the other 2 arguments that I made, you have a situation here where you have an undersized lot. It is a narrow lot. It does not conform to zoning. It is 50 foot wide. As has been mentioned, the building actually is less than what would be required in a 55 if the width of the lot was 55 feet. You have a long, narrow lot. Granted, you have a lot of room in the back, but that doesn't help you because you have a narrow lot that you got to fit this building in. And what they're doing is they're putting a 34-foot building in this lot. It is of no harm to anybody. The extension is in the rear where it can't be seen. The immediate neighbor has no objection to it. For those grounds, also, they're entitled to a variance. So it's any of those 3. I think actually they're entitled to all 3, but that's for the board to determine. Thank you. Thank you for your patience through this, too.
Does anyone on the board have any questions from Mr. Cornelia in the argument? Anyone at all?
I have a question for Mr. Ryan. Do you have any other comment you want to make regarding the legal aspects?
Of the cases that I've had the chance to review in the last couple of minutes, there is a statement in the money case that says, because the ordinance does not specifically bar rebuilding a raised nonconforming structure, the landowners are not per se prohibited from doing so. Now, that kind of a statement would help the applicant. I still think that we have an ordinance that says fire or casualty, and I don't see the money cases dispositive based on a quick rule. And I do know that under the law, you can have a great, substantial degree of regulation of structures on. You can have, and it's been upheld, a rule that says that a 2/3 destruction from whatever source means that you can't rebuild except in conformity. So,
And we have that with use. We say you can't conform. If it's a non-conforming use, you can only build 50%. Our ordinance does say that.
well, also you can. I'm saying in other, like Philadelphia's ordinance, that if you have a non-conforming use or non-conforming structure and it's 2/3 destroyed, you may not resume the use. You have to conform to the zoning ordinance, and that's been upheld. So.
And just the Treadle case, John, I would ask you just to look at that page 2, because it talks about, as I was reading, that provision where the casualty provision in the Treadle case, which is very similar to our case.
But
to our
it's
ordinance.
interesting that the Commonwealth Court said that that wasn't a casualty, and then looking he said the club ignores other provisions which give discretion of the board to allow continuing where there isn't a casualty. We agree. And then they went off on a different section of the ordinance. The Commonwealth Court opinion was overruled, so I'm not going to suggest we look into the heads of the Supreme Court and find out which provisions of the Commonwealth Court specifically they would have saved. But I think that, again, the Treadle case to me stands for what I've been saying all along, that our ordinance governs on this, and that this board needs to look at our ordinance and see what rights, if any, under these circumstances exist to demolish and rebuild.
And that's the point that I'm making, is that the Treadle ordinance, if you read it, is almost exactly the same as our ordinance regarding rebuilding due to fire, casualty, and whatever. And the Treadle ordinance also permits an extension of a nonconformity just like our ordinance. And the court there said the Treadle ordinance did not specifically bar a raising, therefore that the applicant was permitted to raise.
Let me take a look at that for a second.
It's, I think, 28105. I think page number.
Could you, I haven't had a chance to look at Treadle. Can you point me to that language in the opinion?
It's on page 2.
Yeah, second page.
Second page, right there. You can see it. The next to last paragraph.
Yeah. Mm-hmm.
Nick, on this paragraph that you just pointed out, I don't really see how that applies to this particular situation, because isn't the, it says, and such reconstruction is performed within 12 months of such casualty, and if the restored structure has no greater coverage, this does have greater coverage.
That's the same as our ordinance.
It says that?
Yeah, it says same thing.
Yeah, but they then go to 301, and their 301 is very different from our 101B1.
Actually, ours is more expansive.
No.
Because it says you can, actually our 101B1 says that it may continue and be extended provided it doesn't increase the nonconformity, whereas this was more restrictive.
Actually, I think this one is more expansive because it doesn't limit it to dimensional stuff the way our requirements as our 101B1 does. This just becomes, as I read their 3011, this is kind of a zoning board has a very broad discretion to grant special exceptions, and if that special exception, and it doesn't even say special exception, but except unless permitted by the zoning board, and it doesn't talk about a variance, I think that would be treated as a special exception. I think that the 301 is a more liberal version of our 101. Look, I think again, I come back to the proposition that Treadle is teaching me that the zoning board, we have to decide how our ordinance impacts this, if at all, and that's, so my, advice of the board remains unchanged.
Can you
the case is clear. The case is clear, John. I mean, I know you made the position, but
No, I'm not afraid to admit that I'm wrong, but I just don't see you're saying, that this what you're suggesting follows. I think what was before us is this a casualty? And if so, and it may be reconstructed and then basically become another, as a reconstructed non-conforming building, be subject to the approval that was granted in September, which admittedly was an addition under 101B1 to a non-conforming building.
But Treadle specifically addresses the point that was raised here, which is you have two provisions, one the casualty provision, one the extension provision. The Supreme Court said since there was nothing in the ordinance barring reconstruction of a raised building, it is to be permitted. And it's the same as our ordinance. And that, again, that's why I hand up. And the fact of the matter is probably if Ms. McMichael had come to you in September and said, I got to tear this building down, but I'm going to build it on the same footprint, the board in all likelihood would have granted it. And so I guess, in a way I kind of fail to see why it shouldn't be granted this time.
Of course.
Granted, there's some things that happen in between, but again, I urge the board that it was not her fault. She relied on validly issued permits. It wasn't anybody's fault. The permits were issued validly, and she relied on them. And the time to appeal those permits expired. It was 90 days later.
Well, again, the permits have been, have been acted upon in accordance with what they authorize. The permits do not, at face, authorize demolition and then reconstruction of the thing. That's why it's back here to the zoning board to decide. And that's not what the zoning board approved in September. And I don't see the per se language here. It does exist in money, but again. It says here in money, an interesting page 9 of the money decision, where buildings become so dilapidated that complete reconstruction is necessary, a zoning ordinance may bar reconstruction. However, such restriction must be specifically set forth in the ordinance, and absent such regulations, seeking to continue a valid nonconforming use must be permitted to do so. And the question is whether our ordinance, by it limiting itself to, whether dilapidation is casualty or not and fits within, or whether by it's limited to something else, the casualty is not dilapidation, and therefore by specifically saying that for fire or casualty there's reconstruction, that necessarily means that it's not permitted in other circumstances.
Mr. Cornelia. We'd like some more guidance on these cases. Your view of the world is that they're controlling and that they strongly support your client's position. In our limited review, we have concerns about that. So we would like a memo of law on that.
Sure. Yeah, and my understanding, and correct me if I'm wrong, John, I don't think you have to make a decision next meeting. I think you can make a decision beforehand. I think you can deliberate.
No, it has to be done in public. We have
The
to call it
deliberation has to
public.
be done in public,
Oh,
too?
absolutely.
Okay.
The
All right.
decision has to be in public. In fact, what we'd have to do
No,
here-
because I think you come back and announce the decision. I've been in other townships where they don't deliberate in public, but that's fine.
The
If that's what
vote,
this
we
board
see,
wants to
the
do.
vote is clear under the Sunshine Law that the vote has to be in public.
Okay.
And we can, discuss it and all of that, but the actual vote, where you actually get to a vote, has
Oh,
to
right.
be in public.
I understand, yeah. You can discuss it in private, but the actual vote has to be in public. I understand.
I don't want to put pressure on you, but when do you think you can get us the brief?
I'll get it to you. You tell me a
I
week,
understand.
I'll get it to you in a
I
week.
understand.
I'll
Here's
get
what
it
I'd
to you
like
probably
to
before that.
suggest is that, if you can get the brief to us 2 weeks before the next meeting, we continue to the April meeting, and I'd also, would ask as part of that continuance to give us 45 days from the April meeting to render our decision.
The only problem is, and you've heard testimony, is this foundation, we're very concerned. One, I
Right.
think we're going to lose the foundation. It's already been determined that I think they're going to have to,
Well,
it's already
we have
caving
to do
in
our
to
job,
some
though.
extent,
We
and
have
we
to-
have a stop work order, so
Yeah.
we were willing to
Bob,
go
are
in
you
and try
over?
to shore it up,
Is Bob over
but with
there?
the stop work order, we were unable to do that.
Can we?
Bob, is it possible to allow the builder to go on this property to maintain for the purpose of maintaining the footings?
Wait. Well,
Because from what you said, you were not allowed on the property to do any sort of maintenance. Or,
I don't think it's a maintenance issue. I think it is an issue of the health, welfare, and safety. A foundation walls need to be erected in order to safeguard Joyce Barrett, her children, her grandchildren, her great-grandchildren. Right now, she has a driveway that she's scared to drive up and down. I don't blame her. I think I may misspeak, but I do believe that Mr. Cornelia has put forth a letter that we are willing to go forward at our own risk to get the foundation finished and backfilled. That is the only way that we are going to remove this extreme, and I use the word extreme because it is. If you were out at the site, you would see. Her garage could land up in that hole if we had a good soaking rain. And the faster we get the walls up and get them backfilled, then we are protecting the lands of Joyce Barrett. And I would hope that even if we had to come back and wait 45 days or wait for your briefs from Mr. Cornelia, that it would be my hope that at least the stop work order would be lifted and we could go forward to make a safer environment for everyone in Radnor Township.
Can you respond to that, Bob? Do you have any thoughts on that?
It's my opinion that there is no need to do any maintenance on the existing concrete footings that are in the ground. They were poured properly. All indications are they have been protected from extreme cold, and the only other element for concrete is extreme heat. So the concrete has been curing continuously since it was poured. So that's not a concern of need to get on the site and do any sort of anything to the concrete to further protect it. That's stabilized. It is reality, and it was part of my concern 3 weeks ago when I first made the gesture to Township Solicitor Blake that we should consider the open excavation that exists there with unprotected soils, and specifically to the adjoining garage and driveway of the neighboring property being in a precarious situation. And with the spring conditions coming and the potential for rains, and I thought it would be a worthwhile gesture to allow the pouring of the foundation walls, the proper waterproofing of those walls, and the backfilling of the open pit to stabilize what's out there in the field. Thus, we got the letter from Mr. Caniglia suggesting the same and giving his good faith gesture on behalf of the owner that they would be subjected to any decision of the zoning hearing board, the board of commissioners, or the court appeal, the appellant court, as a compromise gesture to allowing them to proceed with the foundation walls and the backfilling process. So, yes, under perfect conditions, I would recommend highly that we do whatever we can to stabilize that open pit with minimally reinforced soils that are continually eroding into the pit as we speak. We need to further stabilize what's out in the field to prevent the possibility or the tragedy of that garage building and the driveway collapsing into the pit.
Okay. Mr. Keneally, do we have that letter in our file?
We do not.
Does it say that at your own risk, and that would be...
You have it in your, it's in one of your exhibits.
Okay. And so that if you were permitted to do that, you would not, that wouldn't be a fact you would be relying on in terms of establishing a hardship, et cetera?
Exactly. That's why I worded it that way, that we understand it would have to be done. I can perhaps read the letter
No, I don't
into
have
the
it.
record.
That'd be great.
I'm sorry, Nick, I don't have it in the exhibits. I thought it was.
I may have it here somewhere.
Well, it doesn't actually bear on the question, so I'm not surprised it's not in it as an exhibit.
But the foundation walls of the basement are in, correct?
Yeah.
They aren't in?
The footers are in, the walls are not in.
Okay.
The footers are in.
Footers are in, and then the dirt's just falling into it?
They're falling in.
Okay.
And really, it's a safety hazard.
Okay.
Okay. I do have the letter. I can read it in the record. I don't have a copy of it unless...
Well, it'll be
when you make a
transcribed.
copy and we can reduce it. Okay. It was dated February 24th, 2009 to Robert Loper. Dear Mr. Loper, as you know, I represent the above property owner. A foundation permit was issued on December 18th, 2008 for the above premises. Pursuant to that permit, the contractor installed the footings for the construction. A stop work order was issued by the Township on January 29th, 2009. Ms. Michael appealed this matter to the Zoning Hearing Board, but as you know, the matter cannot be heard by the Zoning Board until March 19th, 2009. A new paragraph, the contractor has not performed any work at the premises since the issuance of the stop work order. The danger is now that the foundation is incomplete and in danger of being lost if work is not performed until the decision of the Zoning Board. The purpose of this letter is to request that the stop work order be lifted so that the contractor may complete the installation of the foundation in accordance with the permit, that is, pouring the foundation walls, waterproofing, and backfilling for the house, porch, and garage. We understand the owner is proceeding with said work at her own risk. She will have to comply with any final decision reached on the status of her construction by the Zoning Hearing Board and the Board of Commissioners or the courts if appealed. Thank you for your time and consideration. Very truly yours, Nicholas J. Canelia.
Mr. Chairman, could I ask the board retire in short executive session, please?
Yes, 5 minutes. We're back from executive session. Mr. Ryan?
Just to summarize, I looked at the cases. We went back, looked at them together. I feel that there are the Treadle case is less helpful to the applicant than the applicant believes. I think the money case has a helpful statement, but is still, at the end of the day, I come out with that the board has to devote as to how it feels the ordinance on the nonconforming use issue, how the ordinance governs the reconstruction of the tear down for dilapidation. I did advise the board that I do not feel that the applicant has established any claim of vested rights in the permit that would entitle them to relief that they're otherwise not entitled to. And in response to that discussion, the board has decided that they would prefer to vote the case tonight.
First of all, I'd like to echo comments by members of the board and members of the audience about really how this whole thing started and what the expectations were going in terms of whether this building was going to be demolished in the first instance. That being said, my decision is primarily based on my reading of the money case cited by Mr. Cornelia out of Delaware County, out of Haverford Township, in which Commonwealth Court held that where the zoning ordinance does not specifically bar rebuilding a raised nonconforming structure, landowners aren't prohibited from doing so. From my perspective, that's what we have here, and I guess from my perspective, relief pursuant to 280-101B1 would be appropriate.
Basically, you could say that what you're saying is that they could reconstruct the building and then take advantage of the special exception they obtained in September.
That's correct. In addition, I think that in light of the nonconformity of the lot and the fact that I don't believe that a grant of or a construction of a building according to the plans that have been submitted would pose a detriment to the neighborhood. I think variance relief would be appropriate in the alternative. And so as a consequence, I would grant the relief that's been requested in terms of the side yard. Kathy?
I would agree also. And again, I reiterate our thoughts about how this whole thing took place. It's not the best way to go, but we had to look at what the end should be. And I think we agree that relief should be granted here.
Peter?
I agree that relief should be granted, but I repeat what the others have said. I don't like a lot of things that have taken place.
I do concur with Jim.
Relief as the side yard is granted pursuant to the application. Thank you. We're concluded.